From choir to debate to theater, SDPB shines a spotlight on South Dakota's talented students through SDHSAA All-State Fine Arts programming. Good, useful, and full of wonder. SDPB. Every day, SDPB connects South Dakotans with stories that inform, inspire, and bring us together. SDPB, good, useful, and full of wonder. SDPB is your home for fact-based journalism, connecting South Dakotans with news they can trust and stories that matter. Good, useful, and full of wonder. SDPB. From children's programs to in-depth documentaries, SDPB sparks curiosity and lifelong learning in every South Dakotan. SDPB. Good, useful, and full of wonder.
Good morning, everybody. Welcome to this session of House State Affairs. We will now please come to order. I would ask everyone to please take a seat, have your phones turned to silent. If you plan on testifying, please sign in the back. And if you have handouts, have the pages distribute them. If you're a lobbyist, please make sure you're wearing a badge and that it's visible. Please remove your hat if you come in to testify. Welcome if you're joining us online. Our email address is housestateaffairs@sdlegislature.gov. And last, a reminder that all questions and testimony should be addressed through the chair. At this time, I would ask the secretary to please call the roll.
Representative Baumüller.
Here.
Emery, excused. Gosh.
Here.
Hanson.
Here.
Healy, excused. Heineman. Here. Jameson.
Here.
Lems.
Here.
May. Reich.
Here.
Schaefbauer. Overwig. Otenbach. We have a quorum, Mr. Chair.
Thank you, Madam Secretary. We do have a quorum. At this time, the chair will entertain a motion to approve the minutes of the last meeting.
So moved. Second.
Motion by Overweg, second by Hanson. Those in favor of approving the minutes, please say aye. Aye. Opposed, no. The ayes have it. The minutes are approved. I would introduce the pages, but we sent them on a trip down to find our Democrat colleagues, so they aren't here to introduce themselves. We may do that as soon as they get back. Are there any announcements from the committee or personal privileges? Okay. Then let's talk a little bit about the agenda for the day. 6 big, beautiful bills. Because of that, we're going to have to limit it to 8 minutes per side, proponent and opponent, if we have any hope of getting through it. Caution everybody with their questions and their discussion, just to be cognizant of the time that we are under, and we're going to take them in order today. So the first bill up, we are going to jump right in, is Senate Bill 32, entitled Amend and Repeal Provisions Pertaining to the Ballot Requirements for Certain Elections and to Declare an Emergency. Is there any proponent testimony? Welcome, sir.
Good morning, Mr. Chair and members of the committee. My name is Tom Diedrich. I'm the Deputy Secretary of State. This bill is brought to you as a result of Senate Bill 89 last year, which in the general election put the judges on the ballot with everybody else, which is what we had been doing for years and years and years, but it just codified what we'd been doing because it was listed in the code as there's supposed to be a separate ballot. The bill before you is a little more cleanup on there. Because right now the law says committee women and committee men are supposed to be on a separate ballot. Those who are running for a judicial office in the primary are supposed to be a separate ballot for initiated measures and referred laws. Section 4 talks about the State Board of Elections having authority over the separate non-political judiciary ballot. That's getting removed because if you pass this bill, you don't need that provision for the State Board of Elections. There's an emergency clause so that we can get this on the primary. In the interest of time, I'll stand by for questions.
Thank you, sir. Are there any other proponents for Senate Bill 32 here in the room? Okay. Are there anybody online? Nobody online? Any opponents here in the room? Any opponents online? Okay. Then we will move into taking of any questions from the committee. Okay. If there aren't any, let me just take a look at this. Any questions? No questions? Okay, then we'll move into committee discussion or action. Representative Overweg.
Thank you, Mr. Chair. I move to pass.
Motion by Overweg, second by Jamison. Any discussion on that motion?
No, sir.
Okay. Then the motion is do pass on Senate Bill 32. All those in favor will say aye. Those opposed, nay. The secretary will please call the roll.
Representative Baumüller.
Aye.
Emery, excused. Gosh.
Pass.
Hanson. Healy, excused. Heineman. Jamison.
Aye.
Lenz.
Aye.
May. Reich.
Aye.
Schaefbauer. Gosh.
Aye.
Overweg.
Aye.
Otenbach.
Aye.
11 ayes, 2 excused.
After receiving a majority of members-elect, the do pass motion passes. Senate Bill 32 goes to the floor with a do pass recommendation. Should that be on consent? I think it's going to,
Consent, I would say.
okay,
Please put consent.
okay. Then moving right along, we're on to Senate Bill 34, amend provisions pertaining to conducting a municipal or school district election and to declare an emergency. Proponent testimony. Welcome back.
Thank you for the welcome. I'm Tom Diedrich, Deputy Secretary of State. Mr. Chairman, members of the committee, we bring you Senate Bill 34. I wish I could get through this one as quickly as I did the last one, but it's going to take a little bit more time. on it. We're going to make it a little bit simpler for you as I go through it at some point, but I wanted to give you some background. Was, when we put the elections on the primary or on the general ballot, whichever the school or whichever the municipality would like to do, that was fine, but there's a little bit more work that needed to go into getting this just right, as the municipal people will tell you, or maybe an auditor, at least the schools should be here. They were before when we went through this. So what we're trying to do is get notices pretty much the same way all the way through, challenges the same for the different elections, and absentee voting the same for different elections. We asked the Attorney General for an opinion because there were confusion as to, and different interpretations as to what means what words were meaning what. And he gave us an opinion, and we are trying to put it into this bill, or have put it into this bill, and it deals with in conjunction with, which means a temporal means relating to time. I had to look that up in the dictionary. I'm sure you didn't, but I did. But anyway, a temporal phrase that refers to the timing of an election, and combined refers to the sharing of government responsibilities for an election. Doesn't necessarily mean on the same ballot. That's still a question that's open on here. So those are sections 1 and 11. Sections 2 and 7 are mirrors of each other. One is for it defines residency for local elections and removes the challenge provisions so they can be placed in a separate sections. As you're going through here, you'll see that 1 through 6 refers to municipalities and 7 through 12 refers to school districts. So if you're only looking at one of these sections that I name, you're really looking at the other one at the same time. Sections 3 and 8 of the bill introduced new sections to govern election day challenges for local elections. One of the problems that could sit out there is the municipal or the school election challenge as to somebody being able to vote could invalidate everybody's being able to vote. And just because they don't have the residency requirement that they need to have for a school or municipal doesn't mean that they can't vote overall. Those are two different worlds out there. And so we're trying to put these together and say, you have to have the same challenge as the county challenge if you're challenging as a municipal or a school, and it's the same ballot. If it's a different ballot, that's different, because then you can make the challenge separately out of there. Sections 4 and 9 amend publication dates for notices of vacancy. Sections 5 and 10, they amend the publication dates for notices of the election and the facsimile ballots having to be out. 6 and 12 of the bill amend the absentee voting for local elections because those were different. But you can't have, like a 10 or 15 day absentee for part of the ballot and a 46-day for the rest of the ballot. So we put them all the same as we went through here. Section 13 is an emergency clause to get us through the primary, and Section 14 has a delayed implementation so that we aren't messing too much with elections during an election year. I'll stand by for questions. There are other people that need to testify.
Thank you. Is there any other proponent testimony?
Good morning, Mr. Chair, members of the committee. My name is Sarah Rankin, and I'm the Executive Director of the South Dakota Municipal League. The Deputy Secretary did an excellent job of laying out the changes that this legislation provides, and we rise in support of SB 34 for those reasons. These changes are largely technical but critical and important for local officials who are tasked with administering these elections, both accurately and lawfully. We also want to take this time to express our appreciation to the Secretary of State's office for working collaboratively collaboratively with local governments. Over the summer, the counties, the associated school boards, and the municipalities met to try and work through some of these unintended consequences that were referenced earlier. And this bill is a direct result of that partnership and reflects a thoughtful effort to resolve those unintended consequences while maintaining election integrity. So for those reasons, we ask for your support of this bill. Thank you.
Thank you. Any other proponent testimony here in the room today for Senate Bill 34? Okay, then we will turn to opponent testimony. Have we any opponents here this morning in the room? Any online? Okay, well then hearing nothing else from the public, we'll move into committee questions on this bill. Got to be some. Representative Jameson.
Thank you, Mr. Chair, for the secretary, Tom.
Mr. Dedrick.
In section 12, or probably more so in general, I think it states that if the school board and if the county and if the municipality agree to have an election on the same day or on the primary day, I thought they kind of had to. I didn't know that there was an option to agree or maybe disagree. I was just reading it in section 12.
Section 12, lines 9 through 19.
Yes. Thank you, Mr. Chair.
Mr. Chair.
Mr. Dedrick.
Thank you for the question, Representative Jameson. I'm reading it a little bit differently than you are. It does say if, that there is an if. They do have to either have it on the primary or on the general election date. And as I'm looking at it, and again, I'm looking at it rather quickly, but it's to say, if they've agreed for this day, that is the primary day, or if they have agreed for the general election day. They have the choice of which one of the two that they want.
Follow up, Representative Jameson.
Good answer. That's what I was looking for. I was trying to figure it out. He had it right. Good. Thank you.
Okay. Representative Hansen.
Thank you, Mr. Chairman. I just have a question. On section 13 and 14, actually, there's the section that declares an emergency. But it declares an emergency only pursuant to certain sections and not the entire act. And I can't ever recall seeing that before, and I wonder if that's in keeping with our Constitution, which says that no act shall take effect until 90 days unless in case of an emergency. I've just never seen this done this way before, and I wonder if you could comment on the basis for that and your take on whether you think that's in keeping with our Constitution. Thank you.
Mr. Chair.
Mr. Dedrick.
Well, how long do we want to spend? As what you read in the Constitution, I don't see a prohibition to it. And what this would do is get us through the primary and not mess up the rest of the general election timing.
Any other questions from the committee? Representative Lems.
So could you just speak to the absentee, what is allowed for absentee voting right now and how this would change that? Would this be expanding that time frame?
Mr. Chair.
Mr. Dedrick.
Thank you for the question, Representative Lems. It does expand it as far as municipalities and schools if they are on the same ballot as the county. Now, remember, they don't have to be on the same ballot. Even though they may be doing the election on the same day, They may even be in the same polling place, but they aren't on the same ballot. They could have separate ballots. Then they could keep their, what is now in statute as to the amount of time for absentee, which I believe is around 15 days for municipalities and schools, but I'm not positive on that. My apologies. I can get that to you if you want. But it is 46 as far as counties is concerned. But if they're on the same ballot, well then, to try and not make them all the same becomes a logistical nightmare.
Representative Heineman.
So to follow up, Mr. Leader, what you're saying is if they agree to that process, then the counties supersede all the rules, and you have to abide by what the county's rule is as far as the ballot is concerned. Is that what you're saying?
Mr. Chairman.
Mr. Dedrick.
Thank you for the question, Representative Heineman. That's kind of what I'm saying. I'm not saying that the county supersedes. We're just saying that since this is how the county is, the county by itself doesn't supersede.
Okay.
You're the ones who have superseded it by giving the counties the 46 days.
So can you just, maybe you answered already, what is the absentee time now if this bill didn't come into effect for these elections that are being addressed here?
Mr. Chairman, we're not sure. Because if we don't say that it's the 46 days, if they all on the same ballot. So we're going into the primary and the schools, the municipalities, the county are all on the same ballot. As it stands right now, they have different absentee periods. Which one would control, we never asked. And we'd really like to not go down that path.
Okay. Any other questions from the committee? Okay, then hearing none, I'll turn to committee discussion or action. I had one more question, actually. We're going to go back to questions. I had it written down, and then does this bill do anything with, there was some reforms that were made to the PMB type people last year in a bill. Does this touch on that?
Mr.
Can you
Chairman?
speak to that? Yeah, go ahead.
Tom Diedrich, Deputy Secretary of State, a resounding no.
Resounding no, okay.
No.
Okay. That's the only other one I had then. All right, we'll go back to committee discussion or action. Representative Heineman.
I'll move to pass.
Do pass motion by Heineman, seconded by Jameson. Is there discussion on the do pass motion?
Thank you, Mr. Chair. Well, everybody gets a little eerie when there's 6 pages of election to go through code. I can see the conflicts that they have. I do, and to attempt to clean it up is not easy. I remember last year when we tried to deal with the election changes, we had one individual come back several times to our committee. So, and I know this is just a follow-up of that. And when we try and combine elections, it sounds quite efficient, but in reality, we're trying to get more people to the polls, but the process of doing that is sometimes a little bit of a nightmare. So I would encourage you to support this bill and move it to the floor. Thank you.
Any other discussion on the do pass motion? My concern I have is this absentee period being so darn long. I think we should have trimmed that down long time ago. And now what I see here is we're taking it up to this 46-day or 45-day, 46-day period. Representative Lems?
I would echo your comments, and I mean, I'd like to see the ballot just keep them separate.
Okay, any other discussion on the do pass motion on Senate Bill 34? If I don't hear any, I'll move on to asking our great secretary to please call the roll.
Representative Baumüller.
Aye.
Emery.
No.
Gosh.
No.
Hanson.
No.
Healy.
No.
Heineman.
Aye.
Jameson.
Aye.
Lems.
No.
May. Excused. Reich.
Oh, she's
Is she
here.
Oh, I
She's
couldn't
just
see you.
sleeping.
I looked down there. Sorry.
Don't excuse Representative May.
Okay. Reich.
Aye.
Schaefbauer.
No.
Overwig.
No.
Odenbach.
No.
Okay, we have 4 ayes and 9 nays.
Okay, after failing to receive a majority of members-elect, the do pass motion fails. Are there any other motions on Senate Bill 34?
Mr. Chair.
Representative Gosh.
I'll move 41st day.
Motion by Gosh, second by Overwig. Is there any discussion on the 41st day motion? Okay, then I will ask the secretary to call the roll on that, please.
Representative Baumüller.
No.
Emery.
Aye.
Gosh.
Aye.
Hanson.
Aye.
Healy.
Aye.
Heineman.
Nay.
Jameson. Lems. May. Reich.
No.
Schaefbauer.
Aye.
Overwig.
Aye.
Odenbach.
Aye.
Okay, 8 nays, 8 yeas, 5 nays.
Thank you, Madam Secretary. After receiving a majority of members-elect, the 41st day motion passes. Senate Bill 34 is sent to the 41st day. Okay, so we will move along to Senate Bill 93, an act to prohibit certain state officers or employees from being employed by an organization that was the recipient of a contract awarded on behalf of a state agency for a period of time. 8 minutes aside. Proponent testimony. Welcome, Senator Reed.
Thank you, Mr. Chair, committee members, and thank you for the opportunity to present Senate Bill 93. I want to begin the same way I did in the Senate. This bill is not about C.J. Swan Economic Development Project, and it's not about any individual. I support the C.J. Swan project and believe it will be good for South Dakota's economy. And as I stated before, Steve Westra followed current law. This legislation does not allege wrongdoing by anyone. Senate Bill 93 is about strengthening public trust in state contracting going forward. Under current law, state officers and employees who approve, award, administer, supervise, or recommend a state contract may not derive a direct benefit from that contract for 1 year after leaving the state's service. Senate Bill 93 makes a narrow target adjustment in limited circumstances. The focus here is on high-value contracts. I'm sorry, I'm going to back up. Specifically, when a state contract exceeds $5 million, the bill extends the post-employment restriction to 2 years for an individual who has direct authority or meaningful influence over that contract. Contracts valued at $5 million or less remain under the existing 1-year standard. The focus here is on high-value contracts involving significant public dollars and substantial discretion. A longer cooling-off period in those limited cases helps ensure decisions are made solely in the public interest and reinforces in the integrity of the process. As this bill made its way through the Senate, an amendment was adopted to further strengthen transparency while providing appropriate flexibility. The amendment allowed a governing body to grant a waiver permitting an officer or employee to be employed by the company that was awarded the contract, provided full written disclosure is made and the governing body determines the arrangement is fair, reasonable, and not contrary to the public interest. When such a waiver allowing employment is granted, the governing body must notify the Government Operations and Audit Committee. This creates an additional layer of legislative visibility and oversight while still allowing case-by-case discretion when appropriate. This bill does not prohibit employment across the board. It does not create a fiscal impact. It does not discourage economic development. It is a forward-looking policy adjustment designed to create a clear and appropriate separation between public service and private gain in limited, high-value situations. At its core, Senate Bill 93 is about maintaining confidence in how major state contracts are awarded and administered. It is narrow, reasonable, and focused on protecting public trust. I respectfully ask for your support of Senate Bill 93, and I'll stand by for questions. Thank you.
Thank you, Senator. Any other proponent testimony here for Senate Bill 93? Nobody in the room, nobody online. Any opponent testimony here in the room for Senate Bill 93? And nobody online. Okay, then we will close that portion and move on to committee questions. Is there any questions from the committee? Rep. Heineman.
Thank you for the prime sponsor, please.
Senator Reed.
Mr. Leader.
Go ahead.
I saw it was amended, and you didn't address or you didn't say too much about that, but the section that says it goes from 1 to 5 million, can you expound a little bit on that? You know, why that threshold was arrived at, please?
Senator Reed.
Mr. Chair. Thank you for that question. Yes, I did forget that that's also a change that was made as this moved through the process. It was realized that $1 million contract, especially with all the rural health care money that we will, be appropriating or administering over the next 5 years, that it probably want to do it over $5 million. That's where we came up with that number.
Any other questions from the committee? Representative Hansen.
Thank you, Mr. Chairman. Thank you, Senator, for being here. I just have a question about this Section 3. And you mentioned it in your testimony. I appreciate that. And I wonder if we could just sort of talk through that together. So essentially, this allows for a governing body under certain conditions to sort of exempt from the requirements of this bill. And so maybe you could just, one, say a little more about that. Number two, who are we talking about when we say governing body in this language? Because to me, it's not clear. Maybe there's a definition somewhere, but I'm just not seeing that. And maybe we could just start with that question. Thank you.
Senator Reed.
Thank you, Mr. Chair. Did you want me to start with your last question? Is that was
Yes,
your
please.
question? Sure.
Yeah.
Mr. Chair. Tim Reed, District 7. I don't think I introduced myself when I first sat down, so I apologize for that.
Welcome, Senator Reed.
Thank you. So the governing body is defined in 5-18A-17.6, and it's sub 3. Governing body, the Executive Board of the the Legislative Research Council, the Supreme Court, the Board of Regents, the Public Utilities Commission, each constitutional officer, the Board of Trustees of the South Dakota Retirement System, and the State Investment Council, or the governor.
Follow-up, Representative Hansen.
Okay, thank you for that. So when we say the governing body, we're saying then we would allow the governor solely under Section 3 to sort of work around what would otherwise be the protections in this bill.
Mr. Chair.
Senator Reed.
Yes, that there is the or in that line. This came from, and if you look at Section 2, it's the same. Let's see, make sure I have this right. Yeah, so if you look back at Section 2 of the bill, basically we took that language that was already in place for contracts, for when you derive a benefit from a contract, not necessarily employment, right? That's where we took that from. So it's the same process, except I think we added in, and the Government and Operations Audit Committee was also in there. And so that's where we took it from. So it's the same thing as if you're driving, if you have a contract and either you leave and it's your company that actually got the contract, or maybe at times, which I don't think happens very often, if you're actually employed by the state. And so that's where we came up with that language, and it is the same. And it also refers to the governing body.
Representative Hansen.
Okay, thank you. So I wonder if you could just explain the impetus for that amendment, because it seems like, you know, the original version was much stronger. And then with Section 3, especially with the definition of governing body, it allows for just unilaterally the governor to say, we're just going to ignore the provisions of this bill, essentially, kind of work their way around the protections that you're trying to craft. So where did this amendment come from in the Senate?
Mr. Chair.
Senator Reed.
It was in fear of getting, an example that I've used is, you know, let's say you have someone, you know, pretty fresh out of college who goes to work for GOED and is active with a contract, you know, like CJ Swann's. And that person really didn't have that much influence. Might have had some just because of the way they were working through it. And then it's time for that person to move on, because I think a lot of times state employment could be your first job. And then they want to move on to the company. The company identified that as a, you know, pretty good person that could come in, you know, probably not at a higher level, probably at a lower level, and work for us. And I hate to limit somebody from improving, you know, their jobs, you know, moving through kind of the ladder, their career ladder. And so that's the kind of thought that was there.
Representative Schaefbauer.
Thank you, Mr. Chair, for the prime. Go into section 3, the lines 21 through 25, and it says the governing body must provide authorization in writing. So, and then it says that it needs to give annually a report to GOAC. Does it need to, I mean, does it have to go through any authorization, like through, you know, before this, whoever the employee will be that is getting awarded this contract? What if somebody has a issue with it and you provided it in writing? Do they get to, you know, say something about it, or how is that? I mean, I see it's in public record. Can you just, you know, kind of go through a scenario when it would be published and if somebody can counter that?
Senator Reed.
Mr. Chair, thank you. The idea here is so government operations and accountability could act on, you know, could do something about that, you know, the information. It will probably be past the time that it's all happened, but at least they'll have the information and be reviewing it in their meetings and can, you know, at least bring to the public that this might not have been correctly done.
Follow up.
So somebody gets this contract, you know, there's an authorization written, and let's say 8 months later, it's finally going to GOAC, and they can't have an issue with it until 8 months after this person is awarded the contract. I mean, where are the checks and balances with that?
Mr. Chair.
Senator Reed.
You are correct in your statement. And really, we were taking this from the same thing that would happen with a contract. So I didn't want to get different there. I mean, if that's something in the future that needs to be corrected, it sure could be. But then it should be corrected, you know, both in Section 2, which is actually 5-18A, 17.2 should also be corrected there. So it's the same thing for contracts also. But I wanted to keep them the same.
So just so I can maybe understand what the previous question, Senator Reed, so current law that's being amended here was basically if you had responsibility for approving this, you were out for 1 year unless it was essentially okayed by the governing body. And in that case, the person who got the okay it was the person who had to provide a full written disclosure, and they reviewed it, et cetera. And so it was 1 year. What you're doing here, and you can correct me if I'm wrong, and this is a question, you're essentially saying, well, it's still 1 year if it's $1 million or less. If it's 5 million or above, it goes to 2 years. And the only change as far as the approval is that the governing body now has to put it in writing that they approved it. Whereas before in as you see in section 2, the officer or employee had to provide a full written disclosure and then they could okay it however they would do that. Now it's just basically saying the governor, shall we say, has to put it in writing that yes, I have approved it. So we've added a 2-year deal if it's more than $5 million, and we've added the governor does a memo or whatever. That's essentially what this bill does. Is that correct?
Mr. Chair,
Go ahead.
yes.
Okay. Any other questions from the committee? Representative Heineman.
I'm still a little bit confused. So you're going through this structure of how to set these guardrails, and then you have this exception, which the former speaker mentioned, but then there's no recourse. So I'm a little confused as to how that makes sense.
Mr. Chair.
Senator Reed.
So I think we have to go back to the very first part of this, and that is it extends, if the contract is $5 million or more, it extends it to a 2-year waiting period. Okay, so that's the main thing that's happened. But secondarily, because we were worried about getting some people caught up in this, that really, it'd be unfair to them that they couldn't go on and work for a company. And so that is why we added Section 3. So it does provide a workaround. I totally agree with that. But I think that's important, or we're not going to get employees, especially I think kind of in the beginning of their career, to come work for the state.
So this workaround you're talking about in Section 3, that's a new thing? I mean, before there wasn't a workaround, essentially?
Mr. Chair, there was for contracts. There was not for employment. So I just added it for employment. So if they're deriving, I should say not just for contract, but if it's just a benefit derived, and that could be maybe, their wife or their spouse had a company that ended up with a contract, right? And that not necessarily that the employee of the state's going to go to work for them. Okay, that it was always in the same way that it is today. This just deals with going to work for the company. So the state employee goes to work for the company that was awarded the contract.
Representative Schaefbauer.
Thank you. Thank you, Senator. So is there any recourse if an employee, goes to work for this contract and GOAC, is notified? I mean, is there a potential of firing the person or, deleting the contract? I mean, to me, it seems that who's going to fire somebody 6 months after they're awarded a contract and GOAC hasn't met yet? I'm concerned about this, and that's what try to fill me in.
Mr. Chair.
Senator Reed.
Yes, again, there is no recourse. It's more about notification that this happened to the Government Accountability and Operations, which they could take up in a public meeting. But at that point, the firing would have to be done by the company they went to work for. And so, I guess you could say that, it's kind of past that time. And again, this is so somebody doesn't get caught up unfairly and is not able to move through their career or go to a different job.
Well, Senator Reed, I'm also assuming in Section 3 your intent there is to make the person who authorizes this, who essentially engages in this workaround, as you call it, to have put it in writing, and it has to pass the political smell test, if you will, because this is going to be there in the file that they did, in fact, as Section 2 says, that the terms are fair, reasonable, and not contrary to the public interest. So they're going to be on record, if I'm not mistaken, as this person who's, accountable to being reelected, let's say, in that case, in saying that it is.
Mr. Chair, I wish I would have come up with that term, political, or said it, political smell test, yes. That's exactly what's happening in Section 3.
Any other questions from the committee? Representative Emery.
Sure. So I'm still just trying to, wrap my head around this. So let me give you a hypothetical real-world scenario. Say somebody from BIT went to work for or oversaw a contract for cloud services and went to go work for Amazon in an entirely different division, would this bar them from working for Amazon?
Senator Reed.
Mr. Chair, thank you for that question. That's exactly why the workaround is put into this. That's exactly what Section 3 is about. This person could be going to a job that had nothing at all to do with the contract. And this gives the chance for the governing body to say, this does not have any issues with the public trust in awarding that contract.
Any other committee questions? Okay, well then we will close that and move on to committee discussion or action. Representative Hansen.
Thanks, Mr. Chair. Well, I would like to offer an amendment, which is to restore the bill to the introduced version.
Second.
Okay, there's a motion by Hansen, second by Lems, to restore the bill to its original version. Is this a voice amendment that, or is this something we've published, or what do we?
It's online. It's just if you click the introduced version on Senate Bill 93, you'll see it.
Okay, we'll be at ease a second while we read this. Any discussion on that motion while our excellent LRC staff is working on that?
Sure. Thanks, Mr. Chair. Well, you know, I'm just looking at what we're trying to do here, and I appreciate sort of the core of this bill, which is to bring about more accountability and really protect the taxpayers and the public expectation that there not be conflicts of interests. And as the senator mentioned, there have been some issues recently that have been in the news. And so I think where he's trying to get at here. My concern is with the additional language that was added in on the Senate side. This is after the senator introduced the bill, of course. This additional language just creates a total workaround. And so it's like we're putting teeth in, but then we're just allowing the teeth to be pulled back out unilaterally by the governor. And so if we want protections, let's do protections. But to me, it seems like with the amended version, in addition from going to 1 million to 5 million, but in Section 3, the new Section 3, essentially we're just setting this up to have some form of protection and then completely watering down the protection again. And so that's my concern. And so that's why I offer the amendment for this committee's consideration. Thank you.
Any other discussion on the amendment while we're working it up here so it can be published?
Mr. Chair,
Representative Emery.
could I guess, have input from Senator Reed on the amendment?
I don't mind. Senator Reed, putting it back the way it started. Senator, yeah, go ahead, then I'll have a follow-up. You go ahead, Representative.
Well, I guess I'm just more or less framing it. Is this acceptable or friendly amendment to your amended bill?
Thank you, Mr. Chair. No, I would not consider it friendly. I think we all know that as we get started with bills and we find that there could be issues, and I think you, Representative, showed a good example of why we had to put this in. And so while I understand the teeth comment, but somebody else might get chewed up in this that really shouldn't, should have the opportunity to move on to a better job.
Senator Reed, maybe you said it, and I'm sorry if you did. Who put Section 3, that amendment, where did that come about in the Senate? committee, the floor? Who did it?
I think we did that on the floor. Oh, and it was my amendment.
was
Is that
your
what you're at? Is that the question?
Yep,
I'm
yep.
sorry,
It
Mr.
was
Chair, was
your
that the question?
amendment.
It is my amendment. Yes, it was my amendment.
Your amendment on the floor.
It was made on the floor, correct.
Do you recall how it, maybe I can look how it passed through on the floor, or was this a unanimous thing on the floor?
Mr. Chair.
Senator Reed?
Yes, it was.
Okay. Okay. Any other on that? Thank you, Senator. So this amendment is going to be known as Senate Bill 93B, and members who wish to read it, or those listening who wish to read it, can look on the LRC website for this bill and look at the version dated 1/15/26 that's called Introduced, or once it gets published, you'll see it there. Is there any further questions or confusion amongst committee members what we're about to do in seeking your affirmation or denial of the amendment? Okay. I think what we're going to do then is I'm going to ask the secretary to please call the roll on Senate Bill, the amendment, motion to amend Senate Bill 93 to Senate Bill 93B.
Representative Baumüller,
Aye.
Emery,
No.
Gosh,
Aye.
Hanson,
Aye.
Healy,
No.
Heineman,
Aye.
Jamison,
Nope.
Lems,
Aye.
May,
Aye.
Reich,
No.
Schaefbauer,
Aye.
Overweg excused, Odenbach.
Aye.
8 ayes, 4 nays, 1 excused.
Thank you, Madam Secretary. Okay, after receiving a majority of members-elect, the motion to amend passes. We are on Senate Bill 93B as amended here. Is there any further discussion on this amended bill or action? Representative Heineman.
Well, I guess since it's changed a little bit, but the last part of Section 2 does have a reporting process with a written authorization, I guess. So I guess that still is retained in there. So I guess I'm okay with supporting the bill.
Any other discussion on the bill as amended? It seems to me as very, very small little baby step, but it makes it slightly better than the status quo. So I'll support it. Anybody else? Representative Gosh? Nope. Okay. We need a motion.
Yeah, Mr. Chair.
Go ahead.
Move to pass.
Motion by Gosh, seconded by Lems to move do pass. Any discussion on that? Okay. Then the secretary will please call the roll. The motion is do pass. All those in favor say aye. Those opposed, no.
Representative Baumüller,
Aye.
Emery,
No.
Gosh,
Aye.
Hanson,
Aye.
Healy,
Aye.
Heineman,
Aye.
Jamison,
Aye.
Lems,
Aye.
May, Reich,
Aye.
Schaefbauer,
Aye.
Overweek excused, Odenbach. 11 ayes, 1 nay, 1 excused.
Thank you, Madam Secretary. After receiving a majority of members-elect, the do pass motion passes. Senate Bill 93, as amended, goes to the floor with a do pass recommendation. Okay, moving along to Senate Bill 101, an act to amend provisions pertaining to the duties of presidential electors, 8 minutes per side. Proponent testimony. Welcome, Senator Hulse.
Thank you, Mr. Chair. And I do have some handouts that I will give to you as well, because there is a remote testifier as well that would be great if he could speak more, because I know we're on limited time. But my name is Amber Hulse. I'm a District 30 state senator. I rise today to advocate for the passage of Senate Bill 101, which mandates that our state's presidential electors cast their votes in alignment with the candidate who wins the majority in South Dakota's general election. This legislation is crucial in preserving the integrity of our election process and ensuring that the will of all of South Dakota's voters is accurately represented in the Electoral College. The phenomenon of what we call faithless electors, those who cast their electoral votes in contrary to the expectations of their state's electorate, poses a significant challenge to the legitimacy of our electoral system. Historically, while rare instances of faithless electors have occurred, underscoring the potential for discord between the popular will and the final electoral outcome, notably in the 2016 presidential election, there was an unprecedented number of faithless electors. 10 electors voted or attempted to vote contrary to their pledges, and while some of those votes were invalidated or the electors were replaced with a process like the one before you, 7 votes were successfully cast for individuals other than the candidates to whom that they were pledged. So this is a real thing that happens. And in South Dakota's history, since I believe in the last 10 years, we've had this occur 3 different times for presidential elections as well. So maybe that's incorrect. In the last 3 presidential elections, I think it's happened. So with that, I'll let some of the other folks come up and testify. We've got somebody who actually works in this process testifying. And then, like I said, the man online is very educated in this issue as well. So thank you.
Thank you, Senator Hulse. Is there any other proponent testimony?
Good morning,
Good
Mr.
morning.
Chair and committee members. My name is Katie Haruska for the Governor's Office. Since the Governor's mentioned several times in sections, I wanted to make sure that you knew that we were on record supporting the process that's being outlined in this bill. To clarify the last speaker, when it's happened the last 3 times, that is that the elector has had a vacancy. It is not that the elector has voted not in accordance with the general election. So just to clarify, the last 3 we have had a vacancy and have had to have a replacement. Section 2 outlines a small tweak to how that replacement elector would be selected. And so I just wanted to make sure everyone appreciated that. I think that this can be implemented. I am the one who's done this for the last 2 times, and it's a little bit complicated to work with the Federal National Archives and the U.S. Senate to get this done, but I think the bill is in good shape. Thank you.
Thank you. Any other proponent testimony? We've got about 3 minutes left.
Good morning, Mr. Chairman. Brett Kennecke. I'm a lawyer from Custer and appearing on my own behalf this morning. I'm a uniform law commissioner from South Dakota, and I just want to call attention to the fact that we have a staffer from Uniform Law Commission on the phone. You'll learn a lot more from her about this than you ever could from me. I'm a supporter. Thank you.
Thank you. Any other proponents in the room? Okay, go ahead.
Representative Rebecca Reimer, District 26B. I'm just going to give a Me Too in support of SB 101.
Thank you. Okay, we will now move to online proponents for SB 101. We have David Weinberg. Sir, can you hear us? If so, announce your name, who you're with, and proceed.
Yes, sir. Thank you, Chairman Odenbach, Vice Chair Overweg, distinguished members of the committee. Thank you for the chance to testify again today in support of Senate Bill 101. My name is David Weinberg. I'm a registered lobbyist for Protect Democracy United, a cross-partisan 501c4 dedicated to defending our freedoms. Under Chief Justice Roberts, the U.S. Supreme Court has unanimously upheld the right of states to pass laws that prohibit their presidential electors from casting faithless electoral vote ballots and that automatically appoint a replacement in such situations. In advance of that set of rulings, many state governments joined together urging the court to reach such a decision in 2020. And that amicus brief wasn't just red states or blue states. It was signed by nearly all of the states, and it was authored by South Dakota and joined by 44 others. One might fairly ask what reason there could be to revisit a process that South Dakota has been using for presidential elections since 1892. But times have changed since then, and the level of external pressure on presidential electors and even threats against them has increased significantly in recent cycles, starting especially in 2000 and 2004, which provided the impetus for the drafting of the Uniform Law Commission model law on which this is based. Currently, 24 states already have laws on the books to automatically replace any faithless electors, and that includes 5 of 6 neighbors of your state. Approving SB 101 would help ensure South Dakota's electoral votes are honored and protected. And now is the ideal time to act before the next presidential cycle starts up again and parties look to nominate individuals to serve as electors. It would also send a helpful signal for other states to take action too. This bill is like an insurance policy against the potential coercion of presidential electors. We make drivers buy insurance before they get behind the wheel, and this would simply be applying that same level of caution to the casting of your state's electoral votes. Thank you for your consideration of this important bill.
Thank you, Mr. Weinberg. Moving along to Carrie Bierman.
Yes, thank you, Mr. Chair, members of the committee. I'm Carrie Bierman, Legislative Counsel at the Uniform Law Commission. Thank you so much for this opportunity to testify in support of Senate Bill 101. So how does Senate Bill 101 work? It requires that an elector take a pledge that he or she will vote faithfully. In the event the elector votes in violation of that pledge, say by casting a blank ballot or voting for someone else, it's treated as a resignation from the office of elector. The vote is not counted, and then an alternate elector who is required to take that same oath to vote faithfully is selected to fill the vacancy. This required pledge has the function of putting an elector on notice that they will act faithfully, thereby ensuring the orderly operation of elections and protecting the will of the people as expressed by the underlying election. Thank you.
Thank you. Moving along, we have Rick Weibel on our list. Sir, can you hear us? Okay, not seeing him. Any other proponent testimony then? Okay, moving along, we will move on to opponent testimony for SB 101. Anybody in the room? Okay, anybody online? Nobody online. Okay, we didn't hear any opponents, so we'll close that and we'll move on to committee questions. Are there questions from the committee? Any questions from the committee? I have one for the prime. We got to have some questions on this. Come on down. It's kind of a why question, I guess. In section 2, you've got this new language here, right at lines 18 and 19. It says, if a vacancy occurs before the day of the meeting, the state chair of the political party that nominated the elector must provide a list of up to 3. Why did you choose the state chair to have that role like that versus any other person, I guess?
Thank you for the question, Mr. Chair. Amber Holst, District 30 Senator. That's pretty common across the board in other states to have the state party chair be the person that selects replacements. And that was language that was agreed upon with the governor's office as well, to have a list of 3 alternatives kind of already on notice that they might be the people that fill those spots as well that are already agreed to by the party. So it's not just some random person out there that gets selected, that they're people within the party that are already party people.
Okay. And then I had a question for Katie Ruska. You said in your testimony, and I'd like to hear a little more, and I think it kind of, I think your testimony was to say that some of the past things that have happened provide the impetus for what we're looking at here today. You said there's been a vacancy, I guess, in the last 3 presidential elections where this has come up. Can you just describe a little more of the details of what happened with that?
Thank you, Chair. So the first time, I think one of the electors had a trip planned and was simply unable to make it to that meeting. This meeting is set by Congress, and it has to be, I think it's in like the second Tuesday in December. There's a very specific time. It has to be at noon on a very specific date. So that was the first one. And then the second one, again, an elector was just unable to make it that morning, and same with the third instance.
Which elector?
I believe it was Matt Michaels was the first one, who happened to be the lieutenant governor. Traditionally, the electors have been a governor, lieutenant governor, and attorney general for the last 3. Those have been who the party has selected at the convention for being the 3 electors. So the first time it was Matt Michaels, and then the second 2 were Governor Noem at the time.
So there was 2 times where Governor Noem was an elector and did not appear. Is that correct?
Mr. Chair, correct. The last time she was in the process of going through confirmation. to become the Department of Homeland Security Secretary.
Okay. Any other questions from the committee? Okay, well then I will move on to committee discussion or action. Committee discussion on Senate Bill 101. Representative Jameson.
I'd make a motion do pass.
Motion by Jameson, second by Baumüller, do pass. Any discussion on the do pass motion?
Just pretty simple. It seems like the necessary steps in order to fix it, so good to go.
Okay, any other discussion on the do pass motion? I'll probably support it, but I always get a little nervous when I hear we've done it this way since 1892 and didn't have a problem. But I guess it sounds like we did have a couple of problems. So, because we've had the problems, we need to have a thing in place to deal with it. Okay, no other discussion, then the motion is do pass on Senate Bill 101. All in favor will say aye. Those opposed, no. The secretary will please call the roll.
Representative Baumüller.
Aye.
Emery.
Aye.
Gosh. Hanson.
Aye.
Healy.
Aye.
Heineman.
Aye.
Jameson.
Aye.
Lums.
Aye.
May. Reich.
Aye.
Schaefbauer. Overweek excused. Odenbach.
Aye.
12 ayes, 1 excused.
Thank you, Madam Secretary. After receiving a majority of members-elect, the do pass motion passes. Senate Bill 101 goes to the floor with a do pass recommendation. Next, we will move on to Senate Bill 190, Provide for the Rights of a Parent, introduced by Senator Grove, seeking proponent testimony for the next 8 minutes, and then same for the opponents. Is there any proponent testimony on Senate Bill 190?
Good morning, Mr. Chair, members of the committee. Heather Baxter, District 34. Today, I'm bringing you SB 190, but first I'd like to move the amendment, which is 190G, and it brings the bill current with the requests of our stakeholders.
Hang on, we will look up the amendment. Okay, we have had a prime ask for us to move Amendment 190G. Is there a motion on that?
So moved.
Motion by Hanson, second by Lems. Any discussion on the motion? Okay, the motion is to amend 190 with 190G. All in favor will please say aye.
Aye.
Opposed, no. The ayes have it. We're on 190G. Please proceed.
Thank you. Can I turn the rest of my time over to the prime Senate sponsor?
You sure can.
Thank you.
Senator Grove.
Good morning, House State Affairs. I am Senator Tamara Grove, District 26, and I apologize, I just handed you a whole bunch of stuff right there. If you would look very quickly, because I only got a little bit of time here, but on the second page of the one that's got the map, it's got like two women, that one, yep, it's got the two women on the front, and then the next page has got a map. And you'll see there on the map, it says, how well does your state protect parental rights? And you'll see in the burgundy color, which happens to be my favorite color, except on this map, that shows the states that do not have parental rights. And guess what? We're one of them, and we're one of the only ones in the Midwest, which is actually kind of shocking. Last night, if you watched the State of the Union, President Trump introduced a family. The young woman was Sage, and he was talking about what happened with parental rights in the educational system. And one of the things that he said is this: it's time to show common sense in government. We can all agree no state can be allowed to rip children from their parents' arms. And that is exactly where we're at. If you look at one of the, it should be the top, it speaks on that in the state of South Dakota, we had, well, I'll just start with last year I brought this parental rights bill. It was very, very small. And one of the reasons why it died on the floor is because it was said that we didn't have enough protections for DPS and, or DHS and CPS. That later that summer in October, we had a CPS person found guilty for falsifying records in regards to children. And so I just want to bring that forward. I think that there's a lot more information that the others will share. I know we don't have a lot of time, but I just want to say that we are a state that we are not protecting our parents, and it's time that we do so. I'm going to bye for questioning.
Thank you, Senator. Is any other proponent testimony on SB 190?
Mr. Chair, Norman Woods, Family Voice Action. I see we have, we're 3 minutes in. So I just want to give a little bit of context here, and then we'll pitch to Matt Sharp, I believe, with Alliance Defending Freedom, one of our allies. He's online as well. So one of the first things the bill does is it applies the strict scrutiny test to parental rights. We already do this for freedom of speech, freedom of religion. We're asking for those same protections for parental rights, which is actually not new. If you look across the U.S., there's only 11 states that don't provide these protections either in codified law or through court ruling. There's only 11 states that don't. We're unfortunately one of them. So for most states, either the courts or the legislature telling the courts have said, okay, we're going to do compelling government interest and least restrictive means, that strict scrutiny test, when it comes to infringing on a parent's rights to the upbringing of their kid. Most states do that. We're unfortunately not one of them. That's one of the main reasons for the legislation in front of you. Again, it was mentioned last year, there was a lot of questions. The bill was really short then, but there was, hey, there weren't caveats for the abuse and neglect situations. Or, you know, there's confidentiality sections of the bill, but maybe there weren't the proper caveats. So this year we've added all of those in. There was a lot of discussion on the Senate side of, well, what about medical emergencies? Because we're talking about medical decisions. We added additional clarity. What about abuse and neglect investigations? When is there confidentiality, when is there not? We've added the additional clarity. The bill started off with a caveat that says this in no way gives ability for abuse and neglect. You can't claim anything in this and then go on to neglect your kid and say I had the right to do that. We started off with all of those good, clear caveats of this doesn't apply there. There are roughly 32 states, so we've talked about this strict scrutiny, there are roughly 32 states that have done also the parental rights are fundamental language. So we want to join that majority. I know we're a little bit short on time, so if we could go to Matt Sharp with Alliance Defending Freedom. They're one of the legal teams we've been working with to craft the language. Thank you.
Sounds good. Online, Matt Sharp. If you can hear us, Mr. Sharp, state your name, who you're with, and proceed.
Thank you. Good morning, Mr. Chair and members of the committee. I'm Matt Sharp. I'm senior counsel here on behalf of ADF Action. As you've heard, South Dakota is an outlier. The court decisions have not protected parental rights as a fundamental right. In fact, South Dakota courts kind of treat it as a second-tier right. And in our review of South Dakota code, we've not found any of the robust protections that many other states, as we've heard, have passed. That includes recently states like Montana, North Dakota, Iowa, and Idaho, all passing very strong, robust parental rights laws. And those have withstood the test of time. They've showed that they are protecting parental rights to access education records, to access medical records, to be involved in these important decisions, while also, as my friend Norman mentioned, balancing that against those times when the state can and should intervene to protect children from abuse and neglect. Based on our review of this bill, this would actually put South Dakota to having one of the strongest parental rights laws in the country if it passed this. Comprehensive protections that would very ably protect parental rights in all sorts of situations. Finally, I just emphasize this is a very bipartisan issue. In fact, just last week, South Carolina took the first step towards passing a similar law, and their House of Representatives passed it almost unanimously in a vote of 116-1. So we are very excited to see this bill move forward and happy to stay on for any additional questions. Thank you.
Thank you, Mr. Sharp. Any other proponent testimony in the room? Nobody else on? Oh, we have one more. Come on down.
My name is Michael Boyle. I'm a pastor over in Parkston, South Dakota. I've also been a CASA volunteer, and so I've kind of seen some of how that sauce is made, so to speak, and I'm strongly in favor of this bill. Thank you.
Thank you. Any other proponent testimony? About a minute left.
Good morning, Mr. Chair, members of the committee. Everybody before me has said it wonderfully, but I do want to, did I give my name? No, Lisa Gennaro with Concerned Women for America, LAC, sorry. I just want to, again, emphasize this bill still keeps strong safeguards. No changes to mandatory abuse reporting, no delays in true medical emergencies, and exceptions for law enforcement or any investigations. All those are still intact. And you can see that still in sections 2, 5, 7, and 8 of the bill. So we just urge a yes vote on this bill. We just really want to make sure parents are still very involved and that their voices are heard. Thank you.
Thank you. Any other proponent testimony?
Good morning, Mr. Chairman, members of the committee. Michael Pauley, I'm Executive Director of the South Dakota Catholic Conference. Me too. Thank you.
Thank you, Mr. Pauley. Any other proponent testimony? Okay, then we will turn to opponent testimony. Any opponent testimony here in the room? Welcome.
Good morning. I'm Tiffany Wolfgang, Chief of Department of Social Services, Chief of Children and Family Services. I'm here to oppose the legislation as proposed. The South Dakota Department of Social Services strongly supports meaningful parental involvement and recognizes the vital role families play in raising safe, healthy children. For that reason, we don't take this position lightly. In our day-to-day practice, we actively involve parents in medical, educational, and other significant decisions affecting their children whenever it's safely possible to do so. Even when the child is in state custody, our first approach is to engage the parents, keep them informed, and include them in the planning. Parent engagement is not merely a procedural requirement, it is a foundational value of our agency. However, we do have serious concerns with Senate Bill 190 as drafted, that it could unintentionally weaken child protection efforts in the very situations where children are the most vulnerable. South Dakota law requires child protection services to act when there is reasonable cause to suspect abuse or neglect. Working in close relationship with law enforcement and the courts, these cases often require quick, decisive action to ensure a child's safety. Senate Bill 190's parental consent requirements for medical examinations, mental health evaluations, and other protective interventions could delay critical assessments, particularly in cases where a parent is suspected as a perpetrator or refuses to cooperate. In those moments, time matters, and any delay in assessing the injuries, trauma, or immediate safety concerns puts children at risk. We are equally concerned about children who are already in state custody following court findings of abuse or neglect. In those cases, a court has determined that remaining in the home was contrary to the child's best interest. These children have often experienced significant trauma and require timely medical care, mental health services, and stable placements to begin healing. If Senate Bill 190 creates new consent requirements or imposes higher legal standards for routine medical care, mental health services, or placement decisions, it could significantly delay services for children who need immediate and coordinated care. Additionally, procedural barriers risk prolonging the instability and slowing the progress towards permanency. When applied in situations involving an abusive or neglectful parent, the bill's consent framework effectively elevates parental rights over a child's immediate need for protection. Protecting children and families are not competing goals. Senate Bill 190 introduces procedural standards that are unnecessary in the space and risk conflicting with existing precautions. Our agency's priority is always to strengthen families whenever possible and to keep children safe when necessary. We respectfully urge the legislature to reconsider these provisions and ensure that the child's safety remains our highest priority. Thank you for your time and consideration.
Thank you. Any other opponents here in the room? I have a here we go. One more.
Good morning, Mr. Chair, members of the committee. Eric Erickson, representing the South Dakota States Attorneys Association. We think Ms. Wolfgang put it rather well. Really, the reason we're up here is we're concerned about those kids in just the most tragic of situations in these abuse and neglect proceedings. And don't feel this bill does enough to distinguish between children residing with their parents and with those situations we all hope for, and those in state custody per court-ordered A&N proceedings. I know there's a number of other folks to oppose, so we'll end there, but would appreciate your opposition and agree with what Ms. Wolfgang said. Thank you.
Thank you. Any other opponents?
Good morning, Mr. Chair, members of the committee. Heath Larson, Executive Director, Associated School Boards of South Dakota. We represent approximately 845 school board members across the state, the schools they govern and students they serve. Just a couple brief points, as I know there are some other testifiers today. We do believe that parents are a child's first and primary teacher. Couple things, school districts follow what's called FERPA, federal law. All of you are familiar with that. Family Educational Rights and Privacy Act since 1974, that is in place. In addition to that, school districts have parent complaint policies, parent involvement policies, many policies that address what is addressed and talked about in this bill. This bill is not needed. Please send this to the 41st day. Thank you.
Thank you. Any other opponent testimony?
Mr. Chair, members of the committee, Grant Flynn from the South Dakota Attorney General's Office. We too rise in opposition to this bill, largely for the reasons that have previously been stated and the concerns of the effects that it might have regarding our abuse and neglect proceedings. One thing that I'd like to point out to the committee is the proponents talked about South Dakota not having laws or court decisions that implement these kind of fundamental rights. It's my understanding of South Dakota's previous case law that the primary consideration in any of these types of cases, whether it's family law, abuse and neglect, is the best interest of the child, not the fundamental rights of the parents. So we oppose this for the purposes of maintaining that focus on what is in the best interest of the parents, not allowing, or what is in the best interest of the children, and not allowing parents' rights to supersede that. Thank you.
Thank you, Mr. Flynn. Any other opponents?
Good morning, Mr. Chair and committee members. Melissa McCauley, registered lobbyist for the South Dakota Network Against Family Violence and Sexual Assault. We believe in strong families and engaged parents, but we also know the reality that not every home is safe. For many children and teens experience abuse, neglect, and sexual violence, the parent may be the person causing the harm. This bill creates broad restrictions that could interfere with the child's ability to seek help, disclose abuse, and access support services. For that, we do ask that you oppose this bill. Thank you.
Further opponent testimony. Couple minutes.
Mr. Chairman, members of the committee, my name is Justin Bell. I'm a registered lobbyist for the South Dakota State Medical Association, and an attorney from Fort Pierre. I just have a couple comments. Would associate my comments with the prior opponents, but would state, regardless of what you do with this bill, there's a United States Supreme Court case that states that a parent has a fundamental right to rear their children. That's the Troxel decision. So don't believe this bill fails, that there's not parental rights for children. The thing is, though, in current case law, they're balancing various rights in the best interest of the children, and by codifying certain things, you actually would take a step backwards in protecting children in the state. And I would just note, for example, a similar bill failed last year, but that bill was only section 1 of this bill, essentially. The remainder of the stuff was not there. And I believe that the amendment was trying to bring in certain protections of the abuse and neglect chapter, but that's not in section 4, which is the healthcare related aspects of this. And we believe that there are certainly times in abuse and neglect situations where having parental consent required is not appropriate. And so other than what was previously stated, we would oppose this and ask that you send it to the 41st day. Thank you.
Any other opponent testimony? Got time for about some brief Me Too's at this point.
Mr. Chair, members of the committee, my name is Jacob Parsons. I'm a registered lobbyist on behalf of the South Dakota Association of Healthcare Organizations. And to try and be brief then, we do thank Senator Grove for making some amendments on the Senate side with this, but we still have concerns. Two of those being, one, South Dakota Codified Law 25-1-9 allows a minor between the ages of 16 and 18 with parental consent to get married, which makes them an emancipated minor. There's a couple other situations that makes them an emancipated minor. SDCL 25-525 states that emancipated minor shall be considered as being over the age of majority for the following, and goes on to say for the purpose of consenting to medical, chiropractic, optometric, dental, and psychiatric care without parental consent, knowledge, or ability. We believe that Senate Bill 190 sweeping parental consent requirements, if applied to emancipated or married minors, would be inconsistent with their legal status and could expose our providers to contradictory legal obligations. Quickly on the other one, in Section 11 of Senate Bill 190, it creates a private right of action allowing parents to sue for any violation of the chapter with recovery of compensatory damages, injunctive relief, declaratory relief, and attorney's fees. However, multiple provisions of SDCL Chapter 20-9 provide immunity from civil liability to healthcare providers. So with that, we'd ask you to oppose this bill. Thank you.
Thank you. Any other final Me Too's as opponent testimony to Senate Bill 190?
Good morning, Mr. Chair and committee members. I'm Anna Wedham, representing Monument Health out of Rapid City. While well-intended, this bill does conflict with existing South Dakota law and federal protections. Shortly, to keep it brief, when laws conflict, it places healthcare providers in an extremely difficult position. We're making real-time medical decisions, and we do not have the option for waiting for the courts to resolve those legal inconsistencies before we treat a patient. So this bill ultimately puts both providers and patients potentially at risk, so we respectfully ask for a vote no. Thank you.
Thank you. Any other final Me Too's?
Good morning, Ellie Bailey, South Dakota Advocacy Network for Women, rising today in opposition to this bill. Thank you.
Thank you, Ms. Bailey.
Mr. Chair, Ryan Rolfs with the South Dakota Education Association. We also rise in opposition for many of the reasons stated. Thank you.
Thank you. Final Me Too's.
Mr. Chair, members of the committee, Derek Hills, registered lobbyist for the Sioux Falls School District, and we also rise in opposition to this bill. Thank you.
Thank you.
Morning, Mr. Chairman, members of the committee. I'm Diana Miller, registered lobbyist for the large school group, and we also oppose Senate Bill 190 and ask for your deferment and 41st day. Thank you.
Final Me Too's.
Morning, Mr. Chair. Rob Munson, Executive Director, School Administrators of South Dakota. Me too.
Okay. Is there any final opponent testimony in the room? Anybody online? We do have one line online, Ashley Seeklander. We're about out of time. Ashley Seeklander, can you hear us? If so, state your name, who you're with, and give us a brief Me Too.
Thank you, Mr. Chair. My name is Ashley Seeklander. I am a certified school counselor in South Dakota, and I echo in opposition to Senate Bill 190 as a Me Too. Thank you.
Thank you. Okay, with that, we'll give the prime a chance for a rebuttal, whoever it may be.
Norman Woods, Family Voice Action. I want to respond to a few of the things that you've heard this morning and why I don't believe they're valid reasons to vote against the bill. But first I want to start with an overarching question. Why do states or governments apply strict scrutiny to certain situations? For example, freedom of religion. We didn't just decide, okay, we really like that people go to church, so we should apply strict scrutiny. Why? It's because we as a state recognized that religious practice is not just a hobby, it's citizens seeking the truth as revealed to us. So the state said, okay, when things are working well, we want to make sure we don't step in there because we recognize the inherent value to society. Also apply that to free speech. We live in a republic. We didn't just decide that we like to talk. Why does the government put barriers on itself before infringing on the freedom of speech? Because as a state, we've recognized when things are going well, the freedom to speak and discuss and debate is rightly ordered to bring us to success. And we should be really careful to infringe on that. When things are going well, it is naturally ordered to bring us to success. The same applies to parental rights. Outside of abuse and neglect, which we'll get to in a second, who has the best interests of their child at heart? Who is the most devoted to seeking that child's good and well-being and upbringing? Why do we have the cultural phrase mama bear? You don't want to mess with a mama bear. Why does we all know what that means? Because rightly ordered, when things are going well, this is naturally the best way to find the best interest of the child. The parents have the most stake in the game. That's why we should apply strict scrutiny here. Getting into a few of the things you've heard today, a lot of questions about emergency medical services. As we said, we've added caveats into the bill that you can take action, you can do the assessments, you can do medical care if the child's life is at risk, or even just a serious injury. We added in those caveats. We made it very clear. You've heard questions about like, well, after the courts have removed the child through the process, well, then what? And Matt Sharp can get into more clarity here if you'd like later on in questions. But it almost doesn't matter what we would have written into this bill as far as caveats. If the courts have removed a child, it almost wouldn't matter what we wrote in this section. We could put in 100 caveats or none. The courts have removed the child. The courts have already made this separation. That's already a clear process. You've heard that parental consent is being held higher than child safety. Again, back to those emergency medical services. Normally, in everyday situations, again, we already have the emergency service caveat, and we've talked about the court removal. So we're not holding parental consent higher than child safety. You heard from the schools that most of our schools already have these policies. So then they probably agree that they're good. I don't think you can say, hey, we're already doing this and it's a bad idea. You heard that the U.S. Supreme Court has said similar things and offered similar protections. Again, I don't think you can argue that the Supreme Court did something similar, so therefore this is a bad idea to do. From the Attorney General's office, you heard that a lot of the current court rulings are using the best interest of the child test, which is great and needed. But getting back to what we just started off with, when things are going well, the parent has the best interest of the child. And unless you've proven that the parent has gone off the rails, has abused their child, no longer has the best interest of the child at heart, which is all covered under current court ruling, etc., the strict scrutiny for parental rights and best interest of the child, those things don't conflict. Unless the parent is found guilty, and then in that case, again, the court has removed. So there's just a few things I wanted to respond to today. The language has been well vetted, well crafted, and we would ask for your support. Thank you.
Thank you, Mr. Woods. Okay, with that, we'll close the public portion and turn to committee questions. Are there questions from the committee? Representative Schaefbauer.
For Senator Grove, please. Can you give me any examples where parental rights were overruled by the medical establishment, the schools, or the government, and it had nothing to do with neglect or abuse?
Senator Tamara Grove, District 26, Mr. Chair.
Go ahead.
Oh, could I tell my own story?
You've got the mic.
Okay. Very quickly, I had a child who went through the public school system. I found when he was going into 8th grade that he could not read past the 2nd grade. So the school was passing him with A's and B's. I had asked repeatedly for help because I knew he was struggling. His birth mom was drinking and whatever. I think he had fetal alcohol syndrome. I removed him from school. I homeschooled him for 3 years. I then took him to a medical facility to test him to see where he fell on the fetal alcohol syndrome spectrum. The medical facility was utterly disgusted by me because he hadn't had his COVID shots, and he was homeschooled. They threw out all of his lived experiences, told him directly that his problem was me. He went to live with his dad. I was called by the school an unsafe person, and I was removed from his schooling for the next 4 years. And so there's much more to say about that, but that covers many of them, and there is certainly nothing against me from any police report that would say I was an abusive parent.
Any other questions from the committee? Okay. Well, then hearing none, I'll turn to committee discussion or action. Representative Schaefbauer.
Thank you, Mr. Chair. I move to pass.
Motion by Schaefbauer, second by Gosh. Is there any discussion on the do pass motion? Representative Schaefbauer.
Thank you. We all know there are bad parents, but the majority of the parents are good parents. And let us not forget that God, the Creator, gave the child to the parents to raise and nurture and love and do what is best for that child. Yet, there are situations where the parent gets overruled by the schools and the medical establishment, and they think that they have the right to raise that child, which is absolutely appalling to me. We have state agencies for the purpose of neglect and abuse, and when the parent, let's just say, goes off the rails. That's what our government is for. The government is to protect the vulnerable. It is not to tell the parent how to raise that child when that parent is being and is trying to be the best parent possible. I think we forget that parental rights are fundamental rights, and the government does not have, and I'm talking the schools, the medical establishment, they do not have a right to stomp out those rights. So I appreciate Senator Grove and Representative Baxter for bringing this. My heart goes out to the children who are in the situations that they're in because their parents have issues of their own and are not raising those children appropriately. And I thank the governmental agencies for stepping in and helping those children. But parental rights come first. And when a parent loves their child, they will do always what is best for their child. And you're right, the phrase mama bear is there. And kudos to those parents that are fighting for their children, because my heart goes out to them when they are those parental rights are stomped on by the agencies that are out there to to protect, not to overrule, but to protect. Thank you.
Any other discussion on the do pass motion? Representative Reich.
Substitute motion. Move this bill to the 41st day.
Motion by Reich, seconded by Emery to move 41st day. Any discussion on that motion?
Yes, Mr. Chairman. Well, this bill is totally unnecessary. You know, and I want to just say that the one handout here that was handed out by the proponents talking about all the complaints against state employees, when I look at the bottom line of it, there were 4 of them that ended up in criminal charges. One was a correctional officer who provided drugs to inmates. Another one was a South Dakota State University employment who paid veterinary bills, driver's license examiner who accessed photos. It's garbage. I think this bill is an attack on state employees who dedicate themselves every day to help out children, and on school counselors that have got a very tough job. They're underpaid and underappreciated. You know, in the business about a whole bunch of other states have done this, so we need to do this too. That is completely ridiculous. We need to listen to the Attorney General's office, the health care providers, the state's attorney's office, the school boards, people who've dedicated their lives taking care of South Dakotans and specifically our children. And I'd hope you join me in moving this to the 41st day.
Any other discussion on the 41st day motion? Representative Emery.
Thank you. I mean, I guess I just kind of want to echo some of the previous speakers' sentiments. I mean, I think this bill does a little bit overreaching in fact. Again, you know, I think I've said this previously, that we continue to villainize our schools, our healthcare agencies, our state government, you know, and I don't know where we come with this. I mean, I think anybody that's in healthcare, anybody that's an educator, whether that's a teacher, school counselor, or whatever, they have the best intentions at heart. They wouldn't be in that industry if they weren't. And I think this actually does the opposite. I think this actually puts children in a much greater risk of those bad parents that are out there. I mean, yes, there are. I think as a parent, we all value the love, the care for our children, but unfortunately, there are parents out there that just don't give one care about what happens to their child. And sadly, those professionals, those educators, those healthcare providers, those state government employees are their only chance of saving those children. And I think this particular piece of legislation just is an overreach on that. Thank you.
Thank you. Any other discussion on the 41st day motion? Representative Heineman.
Thank you, Mr. Chair. Well, I'm going to resist this motion. I think our consent laws need to be looked at, personally. It seems rather odd, and I've never understood this, that if a 16-year-old comes into me as a dentist and I have to take out a tooth on him or her, I have to get parental consent. And I'm okay with that. I agree to that. But if that same 16-year-old goes into school and goes into a counselor or somebody and makes some accusations or even says something, they seal that record, and the parent they're not allowed to get at that record. And I just think that the consent process needs to be revamped, and I think this would be a good way to start.
Any other discussion on the 41st day? Okay, then the motion by Reich, second by Emery, was to move Senate Bill 190 to the 41st day. All those in favor would vote aye. Those no, I'd ask the secretary to please call the roll.
Representative Baummuller.
Aye.
Emery.
Aye.
Gosh.
No.
Hanson.
No.
Healy.
Aye.
Heineman.
No.
Jameson.
Aye.
Lems.
No.
May. No. Reich.
Aye.
Schaefbauer.
No.
Overwake.
No.
Odenbach.
No.
5 ayes, 8 nays.
After failing to receive a majority of members elect, the 41st day motion fails. Are there any other, well, we're back on the do pass, aren't we? Okay, any final discussion on do pass? All right, then the motion is do pass. All those in favor say aye. Those no, the secretary would please call the roll.
Representative Baummuller.
No.
Emery.
No.
Gosh. Hanson.
Aye.
Healy.
No.
Heineman,
Aye.
Jameson,
No.
Lems,
Aye.
May, Reich,
No.
Schaefbauer, Overweg,
Aye.
Otenbach.
Aye.
8 ayes, 5 nays.
After receiving a majority of members-elect, the do pass motion passes. Senate Bill 190 goes to the floor with a do pass recommendation. That moves us along to our final item of this morning, which is Senate Bill 197, modify the administration of the South Dakota Ireland Trade Fund. 8 minutes max aside. Is there any proponent testimony? Welcome, Senator Carr.
Good morning, Mr. Chair. Chris Carr, Senator from District 11. I'd ask for a little bit of lenience this morning. We have some special guests
Granted.
pertaining to this bill. Thank you very much. Good morning, committee. You know how much I love talking about the South Dakota Ireland Trade Commission, and every year we've had some tweaks. This is a housekeeping bill that Representative Duffy is going to talk about, but I am honored. Thank you.
Can we move the discussions in the back out of the room, please? 1 second here, Senator. Okay, please proceed.
I'm honored to introduce a guest. It is a pleasure. We have a delegation from Ireland, and with me today, sitting next to me, is Deputy Andras Moynihan. So they have a joint committee on ag, and Deputy Moynihan is the chair of that. He leads that. And joining him today is Clerk Christy Houghton and Councilor Grania Rohan. I think I said that right. If you want to stand up just for a second and be recognized. They are here on a trade mission. They're going to be meeting with the Secretary Roberts, the governor, et cetera. And if it'd be okay, I'd love to have the deputy just share a little bit about the importance of these relationships like the South Dakota Ireland Trade Commission. Deputy Moynihan, would you introduce yourself? Hit that button.
Hello.
Welcome.
Thank you. Thank you. Look, it's a huge honor to have the opportunity to address you this afternoon.
Will you state your name?
My name is Andreas Moynihan, Tuchtadala, Chair of the Oireachtas Joint Committee on Agriculture and Food, representing Dáil Éireann and Seanad Éireann. Our committee joint membership, where many of the members are actively involved in farming themselves, spread across dairy farming to contractors, beef farming, and tillage as well. Huge honour to have the opportunity to address you this afternoon. I want to thank the South Dakota Trade Commission for the invite here today, and for the work that's been going on over the last year, 2 years since established, to strengthen trade and relations between ourselves and yourselves. Look, we're here earlier this week exploring opportunities, taking a look at what opportunities are there from trade, but not just with Ireland, between Ireland and South Dakota, but also the possibility of Ireland as a gateway into a 450 million consumer market or opportunity for you as well into the European Union. We had the opportunity yesterday to get out on site around a beef enterprise. Amazing to see so much common ground, a lot of the same issues, struggling to get access to a vet, generational renewal, so much common ground and areas that we can work on, but also knowledge transfer and the whole idea of being able to share our experience. Trade Commission has been over to Dublin last summer. Had the opportunity there to establish links as well with University College Dublin, as well as promote your ethanol business as well, and see if there were opportunities for growing on that. So look, we're heading later on to a conference where we're going to be discussing further, different ways that we can work together. But it's not a case of one day or one event. It's going to be an ongoing and a learning and exploring. It's not you're going to be showing up with an instant trade deal. It's building relationships and growing on it. And just delighted with the opportunity to meet with you and address.
Thank you for being here.
Yeah, thank you for being here. So Just to recap a little bit, what was touched on, this Trade Commission is young, about a year and a half old, but we've already seen some really, I think, impressive progress. The governor himself, we had USD students travel to the department, with the Department of Agriculture, Governor's Office of Economic Development to Ireland. We saw that agreement between the University of Dublin and our university. We had business connections that were made between South Dakota business owners and ag producers and their counterparts in Ireland. I'm just really grateful that Deputy Moynihan and his rest of his delegation are with us today. I'm going to turn it over to Representative Duffy to talk about the crux of the bill. Thank you.
Thank you. Further proponent testimony. Senate Bill 197.
I'd say
Overweight.
that's probably a record for someone who came the farthest to testify in state affairs.
That's quite possible. Quite possible. Welcome, Representative Duffy.
Thank you, Chair. Thank you, Committee. As Senator Carr explained, we have this partnership, the South Dakota Ireland Trade Commission. We started a couple of years ago. Some of you may remember Mark Daly when he was here. He came on what might have been one of the coldest days in legislative history. He talked about it a number of times since then. Basically what all this bill does, and this was Senator Carr kind of outlined this, but when we brought the legislation, the bill is to bring the commission under the legislative branch. It started off with Danner, and it has moved to the legislative branch with the E-Board now in control. But what we didn't bring across was the funding with the area where we can put funding. So they will control the funding. There's no state dollars. This is all fundraising, donations, and things of this nature. So this is nothing more than a cleanup bill. The other thing it does is it takes from require 4 meetings a year down to a minimum of 1 meeting a year. We don't need meetings just for meetings. And so if we need more time together, we will get more time together. So all this does is just simply align the fund with the commission's current structure and makes practical adjustments to the meeting requirements. So basically, that's it.
Thank you, Representative. Any other proponents? Good morning.
Morning, Mr. Chair, members of the committee. Thank you for your time this morning. Timothy Schoenhoven, I'm a policy advisor with your Department of Agriculture and Natural Resources. Our Cabinet Secretary, Secretary Roberts, is a member of the South Dakota Ireland Trade Commission. We've been involved in the discussions that happened in the committee with regards to this legislation. We appreciate the sponsors' efforts to bring this bill. We think these changes make sense. We support it, and we request your support as well. Thank you.
Thank you. Any other proponent testimony? Nobody online? Any opponent testimony? Okay. Hearing none, then we don't need a rebuttal, so we'll move on to committee questions. Are there any committee questions? Okay, then we'll move on to committee discussion or action. Representative Overweg.
Thank you, Mr. Chair. I move due pass.
Motion by Overweg, second by Gosh. Any discussion on the due pass motion?
Thank you, Mr. Chair. Good bill. This is something that it's in its infancy stage, but I hope that we can go further as we go down the road here. This is something we need to look at as a state. Our markets are out there worldwide, and this is an opportunity for us to at least take a peek and see if this is where we need to go. Thank you.
Any other discussion on the due pass motion? Okay, hearing none, the motion is due pass on Senate Bill 197. All those in favor will say aye. Those opposed, no. The clerk will please call the roll.
Representative Baummuller.
Aye.
Emery.
Aye.
Bosch. Hanson.
Aye.
Healy.
Aye.
Heineman.
Aye.
Jameson.
Aye.
Lems.
Aye.
May. Reich.
Aye.
Schaefbauer. Overweg.
Aye.
Odenbach.
Aye.
13 ayes.
Thank you, Madam Secretary. After receiving a majority of members-elect, the due pass motion passes. Senate Bill 197 goes to the floor with a due pass recommendation. Any opposition to consent for that? Okay. And one other comment on consent. The first item today, I made a mistake. Senate Bill 32 we can't have on consent because it added an emergency clause. So that's not going on consent. Any other matters for the good of the order? Oh, we never did have the pages introduce themselves, so we've still got a little time. Would you please just come up to the mic, introduce yourself, state where you're from, and briefly mention any future plans? Turn on the mics. There you
My name is Macy Duffy. I'm from Rapid City Central, and I want to go out of state to study business sustainability.
My name's Connor Newsom. I'm from Lake Preston, and I'm a junior when my future plans are to study pre-dental.
Very good. Thank you for being here. Okay, any other comments from the committee? Otherwise, I will entertain a motion to adjourn.
Mr. Chair.
Overwig.
Move the motion, we adjourn.
Motion by Overwig, second by Hanson to adjourn. All those in favor would say aye. Aye. Opposed, no. We are adjourned, and we meet again right after session today.
SDPB serves South Dakota through an interconnected communication system that is on 24/7, 365. The first place for Amber Alerts, public safety announcements, and EAS messages. SDPB keeps public servants and citizens informed. Good, useful, and full of wonder. SDPB. SDPB brings you closer to your government. With gavel-to-gavel coverage of the South Dakota legislature and in-depth reporting from peer. Good, useful, and full of wonder. SDPB. From early learners to lifelong students, SDPB inspires curiosity through trusted educational programs and resources for every stage of life. Good, useful, and full of wonder. SDPB. When South Dakotans need reliable information, SDPB is there providing updates and coverage that keep our communities safe and connected. Good, useful, and full of wonder. SDPB. SDPB celebrates South Dakota's student athletes with live coverage of SDHSAA state championships, sharing the excitement of hometown heroes. SDPB, good, useful, and full of wonder. From choir to debate to theater, SDPB shines a spotlight on South Dakota's talented students through SDHSAA All-State Fine Arts programming. Good, useful, and full of wonder. SDPB. Every day, SDPB connects South Dakotans with stories that inform, inspire, and bring us together. SDPB, good, useful, and full of wonder. SDPB is your home for fact-based journalism, connecting South Dakotans with news they can trust and stories that matter. Good, useful, and full of wonder. SDPB. from children's programs to in-depth documentaries, SDPB sparks curiosity and lifelong learning in every South Dakotan. SDPB. Good, useful, and full of wonder. SDPB brings South Dakotans together, telling the stories that unite small towns, big ideas, and the people who make our state shine. Good, useful, and full of wonder. SDPB. SDPB shares the voices and experiences of South Dakotans, preserving our stories, our culture, and our sense of place. SDPB, good, useful, and full of wonder. As South Dakota's public media network, SDPB serves everyone with transparency, integrity, and commitment to open access. Good, useful, and full of wonder. SDPB. SDPB helps shape South Dakota's future by educating, informing, and inspiring the next generation of thinkers, leaders, and creators. SDPB. Good, useful, and full of wonder. SDPB serves South Dakota through an interconnected communication system that is on 24/7, 365. The first place for Amber Alerts, public safety announcements, and EAS messages. SDPB keeps public servants and citizens informed. Good, useful, and full of wonder. SDPB.
Good morning. It's time to bring the Senate State Affairs Committee to order. I'd like to welcome everybody here in the room. Ask if you have a cell phone, if you would please make sure that it's silenced. If you're planning to testify on a bill, you can sign up in the back. Please do that ahead of testifying. It's a little different than it has been in years past. If you need help, our pages can help you with that. If you're online and planning to testify, please be sure to introduce yourself each time you speak so everybody knows who you are. And at this time, I will ask the secretary to please call the roll.
Senator Dybert.
Good morning.
Jensen.
Aye. Here.
Carr.
Here.
Colbeck, excused. Larson, excused. Pischke. Voigt.
Here.
Perry.
Here.
Melhoff.
Here.
Mr. Chairman, we have a quorum.
Thank you. At this time, I entertain a motion to approve the minutes of our last meeting.
So move.
Motion by Senator Perry, second by Senator Voigt. All in favor of approving the minutes, say aye. Aye. Opposed, the same. Motion carries. I see we have one Page who is in the room at this time, so I'm going to ask him to come forward and introduce himself. Tell us who you are, where you're from, what your plans are, and if you want to dance a jig or tell a joke, either is acceptable as long as it's quick.
My name is Will Penfield. I'm from Lemon, South Dakota. After high school, I plan on attending the University of South Dakota to study political science, and I hope to go to law school.
All right. Welcome, Will. I'm assuming your partner is off on a mission? Okay. Well, at this time, we'll start running through our agenda. First up, we have House Joint Resolution 5001, which is proposing and submitting to the voters at the next general election an amendment to the Constitution of the State of South Dakota, prohibiting the transfer of private property to a non-governmental entity for the purpose of economic development or increased tax revenue, and requiring a declaration of necessity. Are there any proponents for HJR 5001?
Mr. Chair.
Welcome. Before we get started, I'm going to limit proponent and opponent testimony to 15 minutes on each side. So if you have a lot of folks lined up, please keep in mind to tighten up your comments so that everybody gets a chance to be heard.
Senator Mark Lopke, District 23, and I have an amendment that I would like to move at this time, HJR 5001E.
So moved.
Second.
We have a motion to move HJR 5001E, was it? By Dybert, second by Pischke. All in favor, say aye. Aye. Opposed, same. The bill is amended, so we will take testimony on the bill as amended.
Well, Mr. Chair, members of the committee, we're now on an amendment here, letter E. The new title is a joint resolution proposing and submitting to the voters of the next general election an amendment to the Constitution of the State of South Dakota requiring a declaration of necessity and clarifying public use of private property taken for or damaged by eminent domain. What this amendment has now done, it's kind of clarified the language, and after having a lot of involvement in conversations with a whole multitude of groups out there, we came up with something that I feel is really a good product at the end of the day. The more input that you can have around a problem, the better solution that you ultimately end up with. And the requirement of why this is necessary is something that, to me, this is kind of the inline of the process of the eminent domain argument and battles that have taken place in South Dakota over the last several years. Throughout that process, we've identified some areas that were lacking of consideration, and that's what I kind of want to explain why this particular language was selected. The part for the public declaration of necessity, that is ultimately going to be put on the books. And in the event of a challenge of an eminent domain battle, there's going to have to be an actual proven documentation and rationalization for why eminent domain is going to be taking place. No longer could just somebody saying so qualify. As well as the next step that we went into was the final sentence now. It's very simple, very short, easily understandable language. For the purposes of this section, public use does not include an increase in the tax base, tax revenue, employment, or general economic health. Eminent domain has always had a purpose in the United States of America and in South Dakota. That purpose was misconstrued in the 2005 Kelo versus New London ruling that included an increase in the tax base was an allowable, qualifiable public use. That's a highly controversial decision that even in the opinion of it, the Supreme Court stated that the states could put more confining regulations in place to do that. And if I could have the pages distribute some information that I have here. I have a general overview of the amendment, as well as the one that I would like you to particularly pay close attention to is the one that has some language that's highlighted in yellow. Following that decision, that controversial decision in 2005, 33 states put protections in place either via state statute or constitutionally. 12 states currently have constitutionalized provisions that are stricter than the Kelo versus New London decision. And what I have put down on the paper, I've selected 4 states: Michigan, Texas, North Dakota, and Virginia. And my intent to show there is that these have been put in place for upwards of 20 years now. There has never been any fallout from them. Their true intent of it to limit eminent domain for a private basis has been achieved, all while ultimately having zero negative impact on utilities. And that is the purpose of defining public use in a manner such as this. I think that is pretty compelling evidence that this is a very responsible way to ensure that property rights are protected in the best manner possible in the state of South Dakota going forward. I would appreciate your support on this amendment.
Thank you, Senator Lapke. Further proponent testimony on HJR 5001.
Good morning, Senators. Representative Spencer Gosh from the same great district, District 23, representing the people of South Dakota really when it comes to this case. Many of you sitting on this committee were serving in a, I'll say it for the record, lower chamber at the time on Commerce and Energy. And in 2022, you heard me say the words that there was going to be a storm coming. Well, today we sit in front of you with an opportunity to put that storm to bed. What you see before you in 5001 comes to fruition over, as you heard my colleague say, the Kelo case. But one more case I want to point out to you is the Benson case. It's Benson v. South Dakota. Now, in the Benson case, it's a really long, drawn-out case. And it started with pheasant hunting, above all things. But where it ended was the Supreme Court ruled that economic development was not a reason for a public taking when it comes to eminent domain. So that is currently the law by precedent today in the state of South Dakota. So I want to make that perfectly clear. By a Supreme Court ruling, that is the way it is today in South Dakota. What we're asking you guys to do today is to solidify that, codify it. Let's put it on the Constitution and put it up to the members, the people of South Dakota, to be able to determine whether or not they would like to protect their property rights for the ongoing future. Thank you, Mr. Chair, and I'll stand by for questions.
Thank you, Representative Gosh. Further proponent testimony on 5001. We're about 6 minutes in.
Thank you, Mr. Chairman.
Welcome, Mr. Speaker.
Thank you very much. John Hanson, Speaker of the House, Representative District 25. And it's an honor to be here to support this amended version of HJR 5001. You know, you heard about the Kelo decision. That's a real threat that exists still today. It's a terrible decision. I think if the Supreme Court were to revisit that decision, ultimately today they would overturn it. But as it stands, that's a threat. And if you know the facts of Kelo versus City of New London, and we don't have to revisit it again, but just to be brief, a lady basically had her house taken without her consent for the purpose of what amounted to essentially a private development that never actually even came to fruition. Imagine if that was you. Imagine if that was your house and you lost it through the force of the government without your permission, and now it's just a level field, nothing even there. I mean, that's a real injustice caused by the Supreme Court ultimately in Kelo versus City of New London. The best way that we can protect ourselves against that kind of eminent domain abuse is by putting this language in our Constitution. I think it's the right thing to do for private property rights in this state. for landowners all across the state of South Dakota. And so I would encourage your favorable consideration. Thank you.
Thank you, Mr. Speaker. Further proponent testimony on HJR 5001. Good morning, Representative May. Welcome.
Good morning, Mr. Chair, members of the committee. Representative Liz May, District 27. Private property is not just dirt. It's somebody's livelihood, it's somebody's home. Generations of people have sacrificed and did a lot of work. This resolution draws a clear constitutional line in the sand, I think. Government cannot take a person's land and hand it to another private party simply because someone promises more tax revenue or economic development. In rural South Dakota, land is legacy. It's where our families are raised, where our cattle are branded, where our roots run deep. This resolution trusts the people to decide whether that protection belongs in our Constitution. And I've got to say, I can't think of anything over the years, as long as I've been here, anything more important than this. Property rights are not negotiable. And so I am encouraging this committee for a green vote on this and to move this forward. Thank you.
Thank you, Representative May. Further proponent testimony. We're at 9 minutes. Welcome.
Good morning, Mr. Chair, members of the committee. My name is Amanda Radke. I am representing myself. I'm a farmer, rancher, landowner, and small business owner from Mitchell, South Dakota. As many of you know, 160 landowners in eastern South Dakota faced the unimaginable when a private out-of-state foreign-backed company came and slapped them with condemnation papers. That became the theme here in the Capitol for several years as we battled for just the simple opportunity to say, yes, we'd like to participate in a project, or no, thank you. We have other plans for our business, our agricultural land, our opportunities, our piece of the American dream. I travel across the country speaking, and all over the nation, similar modern takings are happening. An example of that is in New Jersey. A 175-year farm owned by the Henry family was to be seized for affordable subsidized housing. That battle was ongoing, and thankfully, that land has been preserved for that family. Right here in South Dakota, we need those extra layers of protections to ensure that what was endured by those 160 landowners doesn't happen again. And it's not just farm ground, it's in the city. And so whether you have a corner lot in Sioux Falls or a section of land in Kadoka, property rights are God-given, they're inherent, and they should be protected under the Constitution. Now, changing the Constitution is no small thing. We take it very, very seriously. And so looking at this new amendment, I am fully on support of that amendment because it has been carefully considered by many voices, by many critics, by many people who have shared their concerns. And I think the ultimate result provides certainty, clarity, and absolute Constitution protections that don't actually inhibit on well-established appropriate uses for eminent domain that South Dakotans have worked with these companies in previous years. And so I ask for your favorable support of 5001 as amended, and let's once and for all put this conversation to rest where the people of South Dakota can have the final say in ending eminent domain for private gain. Thank you.
Thank you. Further proponent testimony on 5001. Good morning.
Good morning, Mr. Chair, Senators. Sarah Stever from Lennox, South Dakota. I'm here representing myself. I live on the land that's been in my husband's family since 1892. Sometimes both my husband and I work two jobs to build upon what we want to pass on to our next generation. 41 years of paychecks and a laser focus on our version of the American dream. But that dream of ours also made room for our community. When Lewis and Clark Pipeline wanted to come through, we said yes. We all need water. When they wanted to widen our road and needed our land, we also said yes, because we all wanted a safer road. This amended bill protects those situations when we work together to make our community stronger. It also protects the dreams and hard work of individuals when private companies want to take land because their idea of best use isn't the same as the landowners. This bill is consistent with South Dakota values, gives South Dakotans a chance at the ballot box to give certainty to where we stand on the fundamental right to own property. Please vote yes. Thank you.
Thank you. Is there any further proponent testimony on HJR 5001? Proponent testimony. Good morning.
Good morning, Mr. Chair, members of the committee. My name is Jasper Deagle. I'm a registered lobbyist for the South Dakota Stock Growers Association. Their executive director wanted to be here today but was unable, but did send some comments. I'll just quickly share. The South Dakota Stock Growers Association is the oldest cattle organization in the United States, which was incorporated in 1893 in the state of South Dakota and has within their bylaws and policy to protect private property rights. They are not asking for this to be put into law. They are simply asking you to give South Dakota voters the opportunity to decide at the ballot box. The South Dakota Stock Growers Association encourages you to pass this resolution allowing registered voters to vote at the next general election. Thank you.
Thank you. Further proponent testimony? I don't see anybody moving forward in the room, so we will go online. We have a Jim Manley. Are you prepared to testify at this time, Mr. Manley? How about Heather Maud? Is Heather Maud? Yep, somebody wants in. Yes.
They're reporting that they can't hear anything online coming from you.
We have an IT person coming to work on it. So do you want
So,
to recess for 5 minutes?
are you prepared to testify at this time?
Mr. Chairman,
Yes.
I'm sorry. I'm responding to your acknowledgement earlier.
Okay.
I don't know if you can hear me.
Is this
I cannot
Mr.
hear
Manley?
you.
Yeah, we can hear you. Please proceed.
Okay. I think I hope it's all right if I begin, Mr. Chairman. I'm Jim Manley. I'm the policy director for Pacific Legal Foundation. Sorry, the technology has got me a little flustered. Okay, sorry about that. So Pacific Legal Foundation is the nation's oldest law firm that has been litigating in defense of private property rights since 1973. We've litigated 18 cases at the U.S. Supreme Court, most of them involving the right to protect the right to own and use property. We're very excited to see this amendment coming forward. We think that the amended language that the sponsor's proposing is an improvement over the already strong language that was originally proposed. And I want to point out that it does track very closely the language of the North Dakota Constitution. And those protections have been in place there for decades, and they have helped to protect private property rights in North Dakota. And I'm excited to see South Dakota step up and join North Dakota and a number of other states that have amended their constitutions to protect private property rights and ensure that the sort of abuse of eminent domain that we saw in Kilo never happens in the state of South Dakota. I'd be happy to answer any questions, although, as I said, I can't hear what's going on live in the committee room, so I apologize for the technological situation. But if the committee has any questions, perhaps folks in the room can convey them to me, or I'd be happy to answer them in writing. Thank you.
Yes, well, we are over time. We're at 16 and a half minutes. We have Heather Maud is online. If you briefly want to give a me too and maybe a few very brief comments, I'll allow it at this time. Please proceed.
Good morning. I also can't hear. That's a little disconcerting, but I'll be quick with my comments. My name is Heather Maud. I thank you for the time this morning. My husband and I farm and ranch in Custer and Pennington counties in western South Dakota, and I'm also a small business owner. And we have found ourselves in the midst of a very high-profile private property rights battle over the last 2 years, and I come on to speak in favor of this amendment. I was in Washington, D.C. the second week of February working with the Trump administration on this. And it became very apparent that while they are committed to private property rights, we, with good reason, have separation between our federal and state governments. And as a state, we also have a responsibility to protect our citizens in ways that the federal government cannot and frankly should not. So I speak in favor of this. Agree that Kelo needs to be pushed back at all levels of government. We met with the USDA. They are very committed to that. We also heard testimony while in DC from people in other states whose state governments do not have these protections in place. Excuse me. And the federal government finds themselves in a very difficult position with regard to what their choices are to help them. So I just strongly encourage us to put this on the ballot for the people to decide. And as someone who has been embroiled in a large-scale private property rights battle, I can say that it is very hard and challenging when you find yourself in that. And the more protections and ways that we enhance property rights for the individual citizen within the state of South Dakota, the better. This is certainly not void in our state. We do have citizens, including myself, who face these battles. And the more we can do to protect all of us, the better. Thank you. I also can't hear, but if you have any questions and have a way to get them to me, I am happy to answer them. Thank you.
Thank you, Ms. Maud. Okay, at this time we'll close proponent testimony. We're at 18 and a half minutes roughly, so we will give opponents the same to be fair. So at this time we'll open up to opponent testimony on 5001. Is there any opponent testimony in the room? Good morning.
Good morning, Mr. Chairman and members of the...
Could you turn on your mic?
Sorry about
Thank you,
that.
sir.
Start over, apologize. Good morning, my name is Mr. Chairman and members of the committee. My name is Mike Carbo and I'm the Midwest Region Director for the American Petroleum Institute. API supports all segments of America's oil and natural gas industry, which supports more than 11 million U.S. jobs. Our nearly 600 members produce, process, and distribute the majority of the nation's energy. Thank you for the opportunity to speak today regarding House Joint Resolution 5001. API supports two-way engagement between a pipeline operator and a landowner based on transparency, respect, reciprocity, inclusiveness, and accessibility. In 2024, API published the first edition of Recommended Practice 1185, Pipeline Public Engagement, in partnership with regulators and public stakeholders to support operators creating long-term, meaningful, and durable community relationships on both planned and existing pipelines. Most of the time, agreements over an easement can be reached voluntarily between the landowner and a pipeline operator, with eminent domain only utilized as a last resort. For decades, eminent domain has and continues to be imperative for U.S. economic growth and critical infrastructure development, enabling the construction of highways, dams, airports, railroads, telephone, electricity lines, and more. These projects have become the integrated infrastructure system we rely on daily to communicate with distant relatives, heat our homes, transport food, clothing, and other essential needs. In rare instances, eminent domain is utilized when a voluntary agreement cannot be reached, providing fair market value to the landowner while allowing the development of critical infrastructure. South Dakota currently has 1,000 miles of liquid and over 15,000 miles of gas transmission pipelines, transporting the energy used daily to fuel farm equipment, dry crops, create pesticides and fertilizer, and enable tourism to drive the state's economy. South Dakota currently has one of the strongest property right protections in the nation, and we appreciate HJR's 5001's updated amendment to provide additional clarity on public use and the ability for common carriers to use eminent domain while still allowing for critical infrastructure development. It should be noted, any time a new constitutional amendment is adopted, it creates uncertainty, which jeopardizes our nation's goal of energy dominance and energy security. At a time of global energy insecurity and geopolitical turmoil, lawmakers should focus on policies that support critical infrastructure that transports American energy resources. Increasing pipeline capacity can help ensure that South Dakotans continue to have safe, affordable, and reliable energy that we depend on every day. Thank you for the opportunity to share our feedback today on HJR 5001, and I would also like to thank to the author for his willingness to meet with us prior to the hearing as well. Thank you, and I stand for any questions.
Thank you, Mr. Carbo. Further opponent testimony on 5001. Good morning.
Good morning, Mr. Chairman, members of the committee. My name is Brett Kennecke. I'm a lawyer from Custer, registered lobbyist for the investor-owned utilities. I rise in opposition to this measure, and I want to start by saying I heard the word clear used multiple times in the proponent testimony, and I questioned whether I was looking at the same amendment because there's very little that's clear about this to me. My recollection is that Governor Roden authored and passed a bill in response to the Kelo decision way back in the aughts, and that was passed overwhelmingly and has been working ever since. And so I would submit to you that we should ask the proponents how this differs from that and why this is now necessary, because I don't know the answer to that. I don't know why we need to do this because we passed previous legislation in response to Kelo. So tell me why that's at issue here. The public declaration part in line 15 is something that I think has been part of the law all along, and I don't know why we need to add that at this time. I'm not aware that that's been a problem in the past, but I'd submit to you somebody should ask that question. And then I also notice we talk about according to legal procedure established by the legislature and according to Section 6 of this article, which is not replicated here, so a voter can't see what Section 6 says or understand what that means. And I think we're setting up some kind of an opposition between the procedure established by the legislature and then later statements here. Which is it? And what you're left with then, I think, is confusion in the minds of the voters as to what we're doing here, because I heard people talk about no eminent domain for private gain, and I don't think that's what this reads. I don't think that's what this says. And the voters deserve to have clearly set forth language in front of them so that they can make a decision. We're in the voting booth about what's right for them and for South Dakota. This misses the mark, Mr. Chairman. I would ask you to lay it on the table. Thank you.
Thank you, Mr. Kenny. I'd like to remind anybody online, please make sure that you are muted. Welcome.
Morning, Mr. Chair, members of the committee. Sam Nelson. I'm representing EDPA and Missouri River Energy Services. That's one of your local power generation and transmission units. We rise in opposition to this bill for the reasons Mr. Kennecke stated. I also think a big problem with the bill in the current amended form is general economic health. Nobody knows what that means, and it conflates with public use in ways that are going to cause litigation. Thank you.
Thank you, Mr. Nelson. Further opponent testimony to 5001.
Morning, Mr. Chair and committee. Thanks for having us today. My name is Jordan Lamb, CEO and General Manager of Owyhee Electric Cooperative, serving here rural members in central South Dakota. I have a wife and 2 children. We live just north of the capital, 3 miles. I am here today to oppose this proposal. We support property rights, but we do not support infringing on one neighbor's property rights in a way that harms the broader community. Let me provide an example that happens regularly. We have 2 neighbors that do not get along. One neighbor purchases property next to the adjacent neighbor, wants to build a shop. And I'm not kidding when this happens regularly. Neighbor A, that was the existing incumbent, versus neighbor B that wants to build a shop. Our line ends on neighbor A's property. In order to get that line to neighbor B's, we have to cross neighbor A's property. Now you could say, why not use public right-of-way? Public right-of-way is not always available. In certain instances, we have to negotiate with neighbor A to get the line to neighbor B so neighbor A doesn't infringe on neighbor B's property rights. As a utility, we live and work in the same communities we serve. In many cases, we are a cooperative governed by a board of directors. In our case, a cooperative. Investor-owned utilities also have a board. If we start making inherently bad decisions, the board gets voted off by the member owners in the rural communities. We're elected by the people we serve that own the utilities that we provide. That is exactly why we are concerned about HJR 5001. Utilities rarely use eminent domain. In fact, it's always a last resort for us. The vast majority of our infrastructure projects are completed through voluntary agreements with landowners, but the existence of eminent domain authority plays an important role and bringing parties to the table to negotiate. It allows us to negotiate preferred routing, adjust projects to minimize impacts, and reach fair compensation agreements. When that authority exists in the background, it encourages good faith negotiations on all sides. If that tool is weakened or constitutionally restricted, it does not eliminate conflict. It makes resolution more difficult. Infrastructure such as electric lines, substations, water systems, natural gas lines, and broadband networks must cross multiple properties to serve hundreds or thousands of customers, in my instance, over 1,300 miles of line. A single holdout can delay or block a project that benefits an entire community or region. That can mean higher costs, reliability concerns, and slower economic development. Utility infrastructure has long been recognized as serving a public use because it supports reliability, public safety, economic stability, and disaster response. Narrowing or redefining public use in the Constitution risks creating legal uncertainty around projects that are essential to everyday life in South Dakota. Constitutional language is rigid. If unintended consequences arise, it is very difficult to correct. We believe in fair compensation, due process, transparency, and minimizing impacts on landowners. Those protections already exist, but removing or weakening eminent domain authority entirely takes away a necessary backstop that allows utilities to fulfill their obligation to serve all members of the public, not just those on a specific route. Our opposition is not about expanding authority. It is about preserving a limited, rarely used tool that ensures we can continue to deliver reliable, affordable service to the communities who own and depend on us. Thank you guys for your time. I'll stand by for questions.
Thank you, Mr. Lamb. Further opponent testimony on 5001, and we are at about 10 minutes, so we have about 8.5 minutes to go.
Good morning, Mr. Chairman, members of the committee. Ryan Budmeyer, President of the South Dakota Chamber of Commerce and Industry. We rise in opposition of HJR 5001. I'm originally from Belle Fourche. My great-grandparents homesteaded just northwest of Belle, and so I know, as the previous speaker talked about, the conflicts between neighbors. I know that firsthand, but I do believe that voters deserve clarity at the ballot box and not confusion. This resolution seeks to amend our state constitution by asking voters to discern vague, open-ended language that can cause confusion. The truth is our current system already works. South Dakota's eminent domain laws carefully protect private property rights. The proposed change doesn't fix any proven problem, it just injects ambiguity into our foundational document. Complex issues like balancing property rights with economic progress belong in the legislature, with you folks, through targeted statutes, careful hearings, and ongoing oversight, not rushed into the Constitution with language unclear that voters can't possibly know what they're going to be asked to approve or reject. For those reasons, I respectfully ask you to oppose this resolution. Thank you.
Thank you. Further opponent testimony on HJR 5001. Good morning.
Good morning, Mr. Chair, members of the committee. My name is Ellie Bailey. I'm a registered lobbyist for the South Dakota Rural Electric Association. You heard already from one of our members this morning, so I'll try and keep it brief. We're concerned really with anything that disrupts the current framework. The current constitutional provision has many, many cases that set forth the standard, and this really disrupts that. And while our cooperatives rarely exercise eminent domain, it is a tool that we need. And so whether the consequences here are, intended or unintended, direct or indirect, this would negatively impact our members. And we ask that you oppose this bill. Thank you.
Thank you. Further opponent testimony to HJR 5001. Good morning.
Good morning, Mr. Chairman, members of the committee. Bill Van Camp, and I'm an attorney from Pierre and our registered lobbyist for the Retailers Association. The Retailers Association gets pulled into a lot of the ballot issues that are before the voters in this state based on the interests of our membership. And, in this case, we think that this is unnecessary in the state. We haven't seen an identified problem. We think the ballot's already clustered enough, and it also, we think, at a board level, sends the wrong message to people that are looking at South Dakota and what's on the ballot this year. Again, it's not fixing a problem that exists, and we don't think it's necessary, and we'd ask you to oppose the bill. Thank you.
Thank you. Further opponent testimony. Good morning.
Good morning, Mr. Chair, members of the committee. Corey Rostern, President and registered lobbyist for the South Dakota State Federation of Labor. We too oppose this for all the previous statements.
Thank you. Is there any further opponent testimony on HJR 5001? Good morning, sir.
Thank you, Mr. Chairman and committee. Thank you. Chris Larson, General Manager, Clay Union Electric, Vermilion, South Dakota. Mostly a me too on this, but as a couple of the others that had talked about, as a not-for-profit cooperative, we're concerned about this erases precedents, and precedents will have to be established again through the courts, and my members will end up paying those court costs through their rates. I've been in the electric co-op world for 31 years. We've never had to use eminent domain, and we believe, even though we've never had to use it, it's a tool that we hope that we never have to use. But if we do use it, we take pride that our members are not only our members, they're our owners. And as I believe Mr. Lamb said earlier, if they don't like what we do, they vote us out and they get new general managers. With that, me too, please oppose.
Thank you, sir. Further opponent testimony on HJR 5001. I don't see anybody coming forward in the room. I don't believe there's anybody online. So at this time, we will close opponent testimony on HJR 5001 and go to rebuttal. Welcome back, Senator.
Mr. Chair, Senator Mark Lopke, District 23. I can appreciate all the opponents' testimony, and I'd like to clear up some of the matters that were brought up. You know, first of all, do some of these protections that are proposed here exist in some form today? Yeah, they do. They either exist via codified law or they exist with existing case law throughout the process. But we all know how the winds can kind of change over time. New court battles arise. New legislators 10, 20, 30 years from now could change the system. The one thing that we've always had that we could fall back in the United States of America and the state of South Dakota is our constitutionally protected rights. You know, unfortunately, the founding fathers never thought of something in this capacity, and it's just a simple circumstance of having to accommodate those specific times. This language will exist in the Constitution, hopefully forever, protecting it so that citizens don't have to go to court, so that citizens don't have to go to their legislators. Let's clear up this matter and protect it from now, hopefully, forever. And when it comes to the utilities, that's something that was very carefully handled in the drafting of this legislation, because I know in conversations with many of our utility operators and some of the gentlemen that testified today, it's hardly ever been utilized in the state of South Dakota, because South Dakotans understand the necessity of that, and I appreciate that they've never had to, and I don't anticipate they will, as long as they continue to operate in good faith and with courtesy as they always have. As well as the definition that we are giving public use of not allowing it to be utilized for basically private profit has no impact on the utilities, because we do in fact have existing case law from 2017 that the utilities provide a product that has an ultimate public use at the end of it. So this will absolutely have no impact on our utilities. And I guess as far as kind of clearing up if the language is confusing, you know, I think it's very simplistic language. That was one of the top priorities, to make it easily understandable. And I have confidence in the citizens and the voters of the state of South Dakota. If the last election cycle didn't prove anything, they got out there, they educated themselves. There was a whole plethora of ballot initiatives that a lot of them ended up going the right way, because South Dakotans pay attention and they're intelligent enough to figure it out, and I'm confident that as simple as this is, that won't be difficult to obtain. So I guess in closing, I'd appreciate your support.
Thank you, Senator Lapke. We'll close rebuttal now and go to committee questions. Are any questions from the committee members?
Mr. Chairman.
Senator Pischke.
Thank you, Mr. Chair. I'll ask this to any of the proponents. It looks like you drafted this language similar to what North Dakota has, if I'm reading the handout you have here. How has the North Dakota language impacted the use of eminent domain for transmission lines or electricity, or the utilities, I should say?
Mr. Chair, Mark Lapke, District 23. There has been zero impact on utility transmission lines and infrastructure in the state of North Dakota.
Follow up to that. On your sheet here, it quotes 32-15-02. Is that a codified law, or is that in the Constitution?
That's in their Constitution.
Follow up. And how long has it been in the North Dakota Constitution?
Since about 2006.
Okay, thank you.
Further questions from the committee? Senator Dybert.
Thank you. It's for the prime. So, the last line of the bill or the amendment is "or general economic health." Can you explain or define what that is?
Mr. Chair, Mark Lapke, District 23. General economic health would indicate that if you are profiting, you are becoming, in fact, more healthy. So it would be a way of classifying that public use in order to profit yourself personally is not a qualifier for public use to utilize eminent domain to accomplish such.
Further questions from the committee? Senator Perry.
This will be a question for the prime, and then also a question for the utility. And basically, no impact for utilities. I've had utilities contact me and say there will be impact. So can you explain what their concern is, or have you addressed that concern?
Well, I can, Mr. Chair, Mark Lapke, District 23. I can understand their concern of not wanting it to eventually creep into their arena and affect them. But I can tell you, you know, as they've stated themselves, they've never had to utilize eminent domain, and I don't anticipate they will have to do such. So I consider that to be a non-factor. But again, going back to the existing Supreme Court case law that exists in the state of South Dakota, the product that they're providing clearly is described for public use, and this will have no impact on them.
Could I go ahead and have either for the utilities, Chris Larson or Steve Barnett come up and answer a question on that?
Mr. Chairman, members of the committee, Steve Barnett, General Manager for SDREA.
Mr. Chair?
Yes, go ahead.
Really simple. One of the things that says that we've heard is that there would be concern from the utilities, and I'd just like to know what that concern is. Is it a big concern, a little concern? What is the concern?
Yep. Thank you for the question. Yeah, as you've heard from a couple of our member co-ops at Clay Union and Owyhee Electric just down the road from here, they, as Mr. Lapke said, rarely, if ever, do our member co-ops use eminent domain, but we get landowners to come to the table because we do have that ability to exercise eminent domain. So we do think if this was passed, it would adversely impact our membership.
Further questions? Senator Colbeck.
Yeah, for the prime. Mr. Chair. So we've had conversations, so I'm going to try not to ask questions that I already know the answer to, but I know the intent of this bill is to leave the utilities out of it. but I have another concern that from the last time we spoke, from landowners, that this is going to thrust them into litigation. Can you put my mind at ease on that? Will everything end up in court? Or am I not misunderstanding that? There's some people who think that this, because it's going to be in the Constitution, is going to crack an egg on precedent. Do you feel that way?
Mr. Chair,
Continue.
I think this will actually help to keep people out of court ultimately, because it's going to narrow the scope of what eminent domain can be utilized for and bring it back to what it was originally intended for. So I would anticipate less court cases to happen from that, as well as in all the hours of research that I've done in these other states that have put these constitutional provisions in place, I haven't been able to find one challenge in any of those states. So I would anticipate this should decrease the threat of litigation.
Could I pose that question, that same question to an opponent? Just so it's kind of my main concern here. Mr. Kennecke, is he still in the room or did he have to leave? And I can restate my question if I need to. Yeah, okay, so I just restate the question. So I've gotten emails on both sides, and I know the author's intent, but do you feel that this will cause more or less litigation to landowners?
Mr. Chairman, Brett Kennecke for the Electric Utilities. Thanks for the question. I don't see how it doesn't result in more litigation. To me, it feels like you're sentencing people to more litigation to figure out what this means. This is not clear despite the protestations of the proponents, and it appears to, in some measure, restate current law on the topic. And so the question in the trier or the decider of law, the court, is, well, how is this different and why? And what do I have to do differently from before? We're changing law for some reason. I think that's a fair assumption in everybody's mind. And as I sit here today, I'm not clear on what that is, and I doubt like heck that a circuit judge out in one of the courthouses in South Dakota is going to know that either. Not to mention the fact that projects can be across more than one judicial circuit, and so then you can have different decisions from different courts. We need less litigation, not more, and I say that as a member of the state bar, and I think this leads to more. So thank you.
More specifically to what they're saying is the South Dakota Supreme Court held that South Dakota specifically rejects the holdings in the Kello decision. Can you give me, what is the Kello decision?
Mr. Chairman, just a short question with a long answer. As was stated, the lady in the East Coast state owned a house which was sought to be condemned by the city in which she lived in order to turn the property over to a developer for a retail development, if I remember correctly, and that her protestations on that found their way to the Supreme Court of the United States, where they decided essentially, I haven't read that case in years, but my understanding of that case's holding is that it's left to the legislature to decide whether or not that's an appropriate use of eminent domain authority. And I think this state then passed a response to that, which has been in effect since, and I'm not aware of controversy over that. Is that helpful, Senator? I'm not sure how much.
It is. I just wanted to double check what it was about. Thank you.
Further questions? Senator Perry.
Thank you, Mr. Chair. My question would be for either Spencer Goss or Liz, whichever one would like to come up. Spencer, it's time to run to the front.
He doesn't run. He doesn't run anywhere anymore.
Mr. Chair.
Yes.
This question, I think, is simple, but I would like to know, this group that's bringing this bill is reputable and very good and all that, but there are other groups, South Dakota Property Rights, And Citizens for Liberty and Dakota Rural Action have had letters to us, in advance. And if they're saying no and you're saying yes, why are we going yes? And why should we avoid the no's?
Thank you, Mr. Chair. And I don't pretend to speak for any of those individuals. They are their own entity, and their recent decision was made very, very recent on that decision. I cannot tell you if they understand what the amendment was. I mean, this is a different bill than what they were proposing. If you read a lot of the correspondence there, they're stating their obligation to the word solely, which is no longer in the bill. So a lot of their opposition has been changed with the amendment here today. Again, I just put it before you that it's in the form that it is today, and I think it's great legislation intended for what we started off as when they did support it.
Any further questions? Senator Voigt?
If I could, thank you. Fred, have the sponsor. Senator, if you could you give me a quick history lesson in terms of what occurred this past year in terms of a referendum regarding access to private property owners? Do you see this perhaps addressing that in terms of us going down that path again as a state in terms of addressing to the level of a referendum and the consternation that caused?
Mr. Chair. Mark Lopke, District 23. That's my ultimate hope here, Senator Voigt. It is a process that's played out over the last 5 years that culminated with 180 plus South Dakota farm families, landowners that were served with eminent domain papers based upon, part of what the language here is with that declaration of necessity. They were at mercy of a company just claiming, in fact, to be a common carrier. There was no authoritative board that signed off on that, and they quickly found their legal bills piling up, only to lead to this body approving Senate Bill 201 that would have streamlined the process a little bit and made it a little easier to achieve eminent domain, which is ultimately overturned by a large collective of South Dakotans coming together for one purpose, and they overturned that at the ballot. My hope here is that ultimately with this language, we prevent something like that from ever happening again, because I personally myself lived that, and it hasn't been very fun. In fact, it led me to being here. I'd still like to go home and just chase cows, but I've enjoyed my time here. So my answer to your question is yes.
Any other questions from the committee? Seeing none, I have one as long as you're sitting there, Senator. Some of the opponents have raised questions and pointed to the fact that South Dakota actually does have pretty established precedent against the case that was mentioned earlier, and that by bringing this forward, you're kind of throwing all of that established precedent into question, which could cause further litigation and issues and leave us in a very uncertain point going forward. Do you have any comments to address that?
Mr. Chair?
Yes.
No, I agree. We have some of those protections in place currently. But as I previously stated, those are always subject to another case coming up with a scenario that we haven't even thought of yet, and being subject to changing or turning on a dime. And I said, it's the basis of those protections that we have. If we put it in the Constitution ultimately can't be changed by a court case or by a act of the legislature. It requires a vote of the people of South Dakota, and I guess I feel that this is a way to put this issue to bed. It will ultimately let our bosses, the citizens of South Dakota have their say on the matter, and I think that it would be the best way to concretely protect it for the longest period of time possible.
Any further questions from the committee? Seeing none, we'll close questions and we'll go to committee discussion and/or action. Senator Colbeck.
Just discussion. I understand that the sponsor works very hard on this, and I know what he's trying to accomplish. This is a rock and a hard place for us. We've got people on that used to be on the same side, now on the opposite side, kind of split the half of the half. So I have serious concerns about putting it in the Constitution. I have serious concerns about litigation. That's just kind of where I'm sitting.
Further discussion and/or action. Senator Perry.
And/or action, I move that HJR 5001 as amended receive a due pass.
Second.
We have a motion from Senator Perry, second from Senator Pischke, due pass on 5001. Discussion on your motion.
Whenever we're talking about our bills that we have coming before us, it's the interesting thing is if they just come through easily. This is a bill that's been thought through, it's been worked on. The person that's bringing the bill did not do this hastily, and the proponents that were with this bill were excellent, so I believe that moving forward is the right thing to do.
Thank you, Mr. Chair. I'll just add some more comments as well. I appreciate all the hard work that the proponents have put into this. For me, when I look at the language of this and I look at the language of what's in the North Dakota Constitution and compare those, it's almost identical. And when you talk about, what have been the side effects in North Dakota, it seems to me that, I don't hear our neighbors to the north screaming that they can't get electric lines or utilities in the places that they need to be for projects. So to me, the opponents seem to be throwing a lot of spaghetti at the wall in essence, and I just don't buy it. I think that this is I will disagree with the proponents on one factor though. When he talked about the founding fathers did not think about this, well, they actually did have the taking clause of the Fifth Amendment, which states, nor shall private property be taken for public use without just compensation. They did think about that. They just didn't think about it to this specific detail. So that's one thing. But I think that this is the right path forward to put in the Constitution to protect our private property owners, and I would ask that we vote do pass. Thank you.
Senator Jensen.
Thank you. We talk all the time here about local control. This puts it in the hands of the most local you can get, the individual voter. That's local control. Thank you.
Senator Voigt.
Thank you, Mr. Chair. My perspective is, as the good senator just stated, it's about local control. And we're talking about litigation here if this goes down the path and is approved and sends it back to the people. We're yelling, or concerned about fire in terms of litigation and not doing anything about the anticipation or the possibility of that. My perspective is that being a landowner and having dirt under my nails with our family for 150 years and homesteading that, and having outside entities come in and leverage us to force us to do something we don't want or don't want any part of it. And as one of the proponents indicated, being run over, having to take it clear to court multiple times to get legitimacy in terms of what they've given of their lives is not good. I think this puts the brakes on that they continue to come back after those private landowners that have invested their lives. I support this.
Further comments, Senator Colbeck.
Yeah, I'm just going to resist the motion. I'm going to have to listen to the landowners that think that this is going to end them up in court. I don't know. I just have the worry that if it does go in the Constitution, it's not going to accomplish what we want to, and it could add to more litigation. Even more money spent on things that we don't have to.
Any other comments? Well, I'll just add a couple of comments. I think what we have here, I'm trying to discover what the issue is that's trying to be solved. I've gotten a lot of correspondence from folks who have concerns that this brings uncertainty to where we already have established precedent and certainty. And I'm reluctant to vote in favor of that. So for those reasons, and I would also say that anytime you change the Constitution, it does not necessarily make things clear, because then oftentimes it's followed by litigation to determine what the framers or the legislative intent was, and to establish that through litigation. So I think this is falls into that category, and I also will resist the motion. And with that, I'll ask the Secretary, please call the roll. The motion is do pass by Senator Perry, seconded by Senator Pischke. Please call the roll.
Senator Dybert.
No.
Jensen.
Aye.
Carr. Aye. Colbeck.
No.
Larson, excused. Pischke.
Aye.
Voigt.
Aye.
Perry.
Aye.
Melhoff.
No.
Mr. Chairman, we have 5 ayes, 3 nays, 1 excused.
The do pass motion on HJR 5001, having received a majority of the votes, will go to the floor with the do pass motion. So at this time, we will move on to our next item, which is House Bill 1084, which is an act to amend provisions pertaining to the public availability of information contained in certain records. Welcome, Ms. Haruska. Nice to see you here. Have you been here before this year?
Good morning. I am Katie Haruska. I am with the Governor's Office. And I bring before you a bill on behalf of the Governor, House Bill 1084. What's happening that's warranting this legislation this year? Law enforcement officers and judges are coming under fire. They're being attacked, threatened, and even assaulted in their homes. Unfortunately, a judge and his wife, this happened to in their home just a month ago in Indiana. The way that we're engaging with our justice system is elevating the degree of the dangerous threats and assaults against our judges and our law enforcement officers. When personal information is so readily available, the safety of these individuals is more easily put at risk. And in South Dakota, we won't tolerate it. There's a great deal of personal information and personal data that's available online. One source of that information is the nearly unrestricted and very easily accessible public disclosure on the statewide voter registration rule that House Bill 1062 from last year has now required. One of the consequences of that bill is now the mass publication of the personal address, home address of law enforcement officers and some judges, and it's updated weekly. This bill before you today works within a current exemption. We'll go to the heart of the bill. Section 1 and 2 is just style and form, and Section 3 and 4 is really the core of what we're doing here. Current law already protects state court judges' information from being on this roll. What our bill is doing is simply adds that the same protection is extended towards law enforcement officers, retired state court judges, all of our federal court judges, and if House Bill 1007 passes, which it looks like it will, we'll also add tribal law enforcement officers as well. So please support law enforcement and judges and support this bill. Thank you.
Thank you. Is there any further proponent testimony on House Bill 1084? Good morning.
Good morning, Mr. Chair, members of the committee. Greg Satizan with the Unified Judicial System in support of House Bill 1084. As Ms. Haruska explained, this is really an expansion of the current law that protects judicial home address information through the Secretary of State's voter registration records, but it sweeps in the retired judges as well, which because of the nature of the work, many times when a person leaves the bench, there are individuals that are exiting the penitentiary several years later and could potentially have a grudge related to the judge. And so we think that makes sense. In addition, the federal court judges have had extensive discussions both with us as we've worked with them on their concerns about their own personal safety. And so we've done a lot in the last several years. I would just add that was added in 2022. And so in the last several years, we've really focused as a system on securing the courthouses and making sure that the judges are safe when they're at work. Probably the most pronounced danger at this point in time is when they're out in the communities or at their home. And so in addition to the home address, which is previously protected, this adds telephone number and email information as well as being protected as it's defined in the bill. So we think that this change makes sense and would ask for your support. Thank you.
Thank you, Mr. Satizan. Further proponent testimony on House Bill 1084. Good morning.
Mr. Chairman, members of the committee. Roger Tellinghausen testifying in my own behalf. I haven't registered yet, but I will do so as soon as I finish. As a former state's attorney and former attorney general and the spouse of a lady that was as a retired judge who's now an assistant attorney general, I rise in support of this bill. I have never had the experience of being threatened personally, but I know my wife, as a judge, came under scrutiny from some of the people that appeared in front of her, and it was always a fear that when she was out and about or at our home, that she could be a victim. So we would encourage your support. Thank you.
Thank you. Further proponent testimony on House Bill 1084.
Good morning, Mr. Chair, members of the committee. Jenna Severin, registered lobbyist for the South Dakota Police Chiefs Association. We'd certainly like to thank the governor and his team for bringing this bill and considering law enforcement in the drafting of it and the statutory protections that would be afforded to them under it. For that reason and the other reasons that the prior proponent spoke to, we would ask for your support. And Mr. Chair, if I may have a little bit of latitude to also testify in my personal capacity as an attorney here in the Sixth Circuit. We get to know our judges very well. You see them in the community, you see them at Walmart, you see them everywhere. They hurry through those places to get their groceries, to get their services done, because they don't want to run into any contact with individuals who may have a grudge against them. So I would also speak in my capacity as an attorney, as a proponent for our judges as well. Thank you.
Thank you, Ms. Severin. Further proponent testimony on 1084. Good morning.
Good morning, Mr. Chair, members of the committee. Grant Flynn with the South Dakota Attorney General's Office. We too support this effort. As the Governor's General Counsel pointed out, these protections exist already for our state judges. Our law enforcement, our retired judges, our federal judges face the same concerns as the state judges when the legislature originally put this law into place. And we would ask that you extend those protections to these folks who have certainly earned it, given their important and sometimes dangerous jobs. Thank you.
Thank you. Further proponent testimony. Good morning.
Good morning, Mr. Chairman, members of the committee. My name is Tom Diedrich. I'm the Deputy Secretary of State, and for the reasons given by the proponents, the Secretary of State's office supports this legislation. Thank you.
Thank you. Is there any further proponent testimony on House Bill 1084? Seeing none, we'll close proponent and go to opponent testimony. Seeing nobody moving forward, we will waive rebuttal and go to committee questions. Senator Jensen.
Thank you. I think I have a very simple question for Ms. Huska. These redactions are only on the online search, or if we purchase a mailing list, would we still get those names?
Mr. Chair, thank you for that question, and I conferred with the Secretary of State's office as well. The redactions would be on both.
Further questions from the committee? Seeing none, we'll close questions, go to committee discussion and/or action. Senator Perry.
For action, I would say that we should have a due pass on HB 1084.
I have a motion by Senator Perry, second by Senator Voigt. Due pass. Any discussion on the motion?
This bill is very good. It has good support on the other side of this legislative house, and it contains good information, well presented. It's something that we should support.
All right, seeing no further discussion, I'll ask the Secretary to please call the roll. The motion is due pass on House Bill 1084 by Senator Perry, second by Senator Voigt.
Senator Dybert.
Aye.
Jensen.
Aye.
Carr.
Aye.
Colbeck.
Aye.
Larson, excused. Pischke.
No.
Voigt.
Aye.
Perry.
Aye.
Melhoff.
Aye.
Mr. Chairman, we have 7 ayes, 1 nay, 1 excused.
House Bill 1084, having received a majority vote, is hereby passed. It'll go to the floor with the due pass motion. Do you have somebody who will carry it on the floor? And can you work with somebody, or do you want me to sign it? Okay, thank you. At this time, we'll move on to House Bill 1095, modify provisions pertaining to the submission of a nominating petition. Proponent testimony on HB 1095. Welcome, Senator Hulse.
Thank you, Mr. Chair and members of the committee. Amber Hulse, State Senator, District 30. Due to the way that our holidays are falling this year and the fact that there are 5 Tuesdays in the month of March, and this happens, I guess, every 6 years, it puts our auditors in a tight spot to get the ballots ready in time in order for them to be ready to send out in accordance with federal law for UOCAVA voters. And so this is an effort to ensure that there is enough time to get those very important things done and ensure that we're not taking steps that would actually harm election integrity by not going through proper procedures and using sample ballots and things like that, so that our auditors have the proper time to get the materials ready in time. Thank you.
Further proponent testimony on House Bill 1095. Good morning, Representative Reimers.
Good morning, Mr. Chair and members of the Senate State Affairs. I just wanted Representative Rebecca Reimer, District 26B. I want to thank Senator Hulse for just stepping up. I was just finishing with another committee and they had to take my vote. So yes, I am bringing to you House Bill 1095. And I hope there isn't much discussion this morning because you actually passed this bill last year through this committee and off the Senate floor. So 1095 moves the petition submission deadline from the 2nd Tuesday in March to the 3rd Tuesday in March, aligning the timeline of cities, counties, and school districts, and moving the deadline 1 week earlier to give election officials adequate time to complete their work accurately. And why does this bill matter? Because the election officials don't just print ballots, they must create ballots, export ballots, proof ballots, correct printing or layout errors, test ballots and equipment, print and package ballots, and ship ballots, including UOCAVA ballots on a federally required timeline. When petition deadlines run too close to the federal mailing requirement, there is no margin for error. Every state runs elections a little differently, but nearly all provide more lead time in South Dakota before ballots must be finalized and mailed. Let's see. 1095 addresses a petition submission timeline, ensures consistency among 3 entities in conducting elections, and provides election officials sufficient time to run accurate, secure elections. It's a modest change, and I just want to say there was an emergency clause on in the House. We took that off because we couldn't get it through the House with the emergency clause on, and as a former speaker said, this happened in 2026 or 2020. It's going to happen this year, and it's going to happen in 2032 every 6 years. So this bill is needed, and I would ask for your favorable vote. Thank you.
Thank you, Representative Reimer. Further proponent testimony in the room on House Bill 1095.
Good morning, Mr. Chair, members of the committee. Roger Tellinghuse, an attorney and registered lobbyist for the South Dakota County Officials Association. I'll be very brief, in as much as we have 3 auditors, county auditors, that are standing by remotely to testify. They represent small, medium, and large in terms of the populations of our counties, and we would hope that you would favorably enact this or pass this bill. Thank you.
Thank you. Further proponent testimony.
Good morning, Mr. Chair, members of the committee. My name is Sarah Rinkin, and I'm the Executive Director of the South Dakota Municipal League, and we too rise in support of this legislation. From a municipal perspective, the changes to State Statute 913.7 and 913.7.1 provide helpful clarity and consistency. These updates align municipal election procedures more closely with broader election law, reduce confusion for candidates, and support municipal finance officers in administering local elections efficiently and accurately. Just as importantly, these clarifications help municipalities plan ahead and stay on track with important election deadlines. When the timelines in statute are clear, it cuts down on last-minute confusion, helps staff line up tasks in the right order, and ensures ballots, notices, and certifications are completed on time. For those reasons, cities support this legislation, and we respectfully ask for your favorable consideration. Thank you.
Thank you. Further proponent testimony. Good morning.
Good morning, Mr. Chair. Tom Diedrich, Deputy Secretary of State, and for the reasons given, our office supports this legislation.
Thank you. Is there any further proponent testimony in the room? Seeing none, we'll go online to Lindley Howard. Are you there and prepared to testify at this time?
I am, Mr. Chair. Good morning, Lindley Howard, the McPherson County Auditor. While we would have preferred this to have an emergency clause, we understood the concerns on the House side and still support without the emergency clause. Another week to get ballots out to counties will reduce shipping costs, and that extra time is critical for counties with only 1 or 2 people working in the auditor's office. UOCAVA voters must be sent their ballot on April 17th, or 45 days before the federal election. Shortening the absentee period doesn't change that requirement. And while the April 17th deadline is most likely unobtainable this year due to this bill not passing last session, there have been several years where we are left choosing between paying expedited fees or risk being out of compliance with UOCAVA. Moving the deadline back a week will help. And if circulation needs to start earlier, I'm not sure we would be opposed to that. Standardizing petition circulation times and deadlines across all local governments makes the process easier to follow for local candidates. It makes little sense that a county commissioner candidate has almost double the time that a city council or school board candidate has in the same county, even though the city and school candidate has more signatures to gather, at least in McPherson. We ask for your support of House Bill 1095. This bill is important, even though it does not have the emergency that it did originally. Thank you, and please support.
Thank you, Ms. Howard. Brenda McGurder.
Good morning, Chairman.
Good morning.
And members of the State Affairs. My name is Brenda Magruder. I am the Lawrence County Auditor, and I am coming before you today asking for a favorable vote on House Bill 1095. This bill spells out a cleaner timeline for submitting petitions and withdrawing petitions by the county, cities, and schools due to the passage of legislation last year. So I'm just asking that you vote yes on this. Thank you.
Thank you, Ms. Magruder. And Kathy Glines. Are you prepared to testify at this time?
Here we go. Here I am. Sorry about that. Couldn't find the right button. I'm Kathy Glines, the Harding County Auditor. There's been several that have talked about the tail end of the petition process. This bill also corrects the timelines at the beginning of the petition process. For example, this year with the schools and the towns, they had to publish their notice of vacancy the last 2 weeks of December, but they literally could not start circulating petitions until February 2nd. So there's quite a gap between when the notice goes out to the public that we have vacancies, and hopefully in 5 weeks, you're going to remember you can take out a petition. So these bring all these petitions in line to January 1. Everybody, the school, the town, the county, the state, everybody starts on January 1. Everybody ends on the third Tuesday in March. So it's going to eliminate a lot of confusion for all three entities and to the candidates and to the public. So this is a good bill. We appreciate Representative Reimer working with us on this. Ask for your support. Thank you.
Thank you. Seeing no more proponent testimony, we'll close proponent testimony and go to opponent testimony. Is there any opponent testimony on House Bill 1095? There's none in the room, none online, so we will waive rebuttal and go to committee questions. Does anybody have any questions? Seeing none, we'll move to discussion and or action. Senator Dibert.
I would move do pass.
We have do pass by Senator Dibert, second by Senator Jensen. Discussion on the motion.
Thank you, Mr. Chairman. I think this is a good idea. It's a result of what we did last year, making the elections the same time, so it clears up some of the details to get to that point.
Seeing no further discussion on the motion, the motion is due pass by Dibert, second by Jensen. Secretary, please call the roll.
Senator Dibert.
Aye.
Jensen.
Aye.
Carr.
Aye.
Kolbeck.
Aye.
Larson, excused. Pischke.
Aye.
Voigt.
Aye.
Perry.
Aye.
Melhoff.
Aye.
Mr. Chairman, we have 8 ayes, 1 excused.
House Bill 1095, having received a unanimous vote, is hereby passed. And that would certify for consent if there's no objection. Seeing none, we'll put that on the consent calendar. Thank you. Moving on, we'll go to our last bill on today's agenda, House Bill 1102, rescheduled the annual report filing date for a limited liability company and a limited liability partnership. Do we have proponent testimony on 1102? And I see there's a lot of amendments sitting out there. Do we want to move any of those, or are we good?
We do. Good morning, Mr. Chair and members of the committee. Heather Baxter, District 34, and I would ask that we move Amendment I.
Mr. Chair,
Senator Pischke.
I motion to amend House Bill 1102 with 1102I.
We have a motion from Senator Pischke, second from Senator Carr, I believe, to amend the bill. All in favor say aye. Aye. Opposed, the same. The bill is amended to 1102I, so please proceed with your testimony.
Thank you. South Dakota has many businesses and entities that are required to file an annual report. HB 1102I is a strategic approach to build support for amending codified law sections 59-11-25, which reschedules the annual report filing deadlines for all individuals with multiple entities. Currently, if you have 10 LLCs, you could have up to 10 separate anniversary filing dates. This bill would allow the owner to choose between 2 filing options. Option 1, they file as they have historically done with a due date with each entity in relation to its data formation, which may require the individuals to file multiple times per year if they have more than one entity. And number two, they can choose to file by January 31st, regardless of their formation date for all entities at one time. This also allows any entity in good standing to switch between the filing date options at their choosing. Voting yes on this bill is a straightforward win for South Dakota business owners, economy, and administrative efficiency, and it's a smart update that positions us as innovators in governance. I would ask for a yes vote, and I'll stand by for questions. Thank you.
Thank you, Representative Baxter. Is there any further proponent testimony on House Bill 1102? Senator Hulse.
Thank you, Mr. Chair and members of the committee. Amber Holst, District 30 State Senator. Just going to say a me too. The amendment updates so that it includes all types of entities, because originally it wasn't going to include all, and it makes it an option so that a business owner, if they don't want to do it in the manner that this is prescribing, that they can choose. So it's good for business.
Further proponent testimony in the room? Good morning, sir. Please introduce yourself.
Good morning, Mr. Chairman, members of the committee. I'm Rob Wardeman from Rapid City. I supported 1102 when it passed the House State Affairs unanimously, and I support 1102I today because it accomplishes the same goal of allowing individuals with multiple entities the ability to file all annual reports on one landmark date. Currently, if I'm the registered agent of 6 entities with different formation months, I have 6 annual report deadlines to keep track of. 1102I would allow me to reschedule all of my annual report filing deadlines to January 31st, streamlining the reporting process, allowing me to file 6 of them on one date, making the process more business friendly and making it easier for me to stay compliant, and freeing up the other 5 months to focus on the day-to-day responsibilities instead of trying to track multiple random reporting dates. 1102I also addresses the issue of flooding the SOS office with a single reporting option and mitigates the potential for mass delinquencies on the first cycle of implementation of 1102 in its original form. I'd like to thank the prime sponsor and the Deputy Dietrich for working together to put together this win-win amendment. Thank you.
Thank you. Is there any further proponent testimony inside the room? Deputy Dietrich, welcome.
Good morning, Chairman Melhoff and members of the committee. My name is Tom Diedrich. I'm the Deputy Secretary of State, and with the amendment, we support this. It took it away from a mandatory deal to an optional that we thought was important. It also brought in all entities, which we really wanted to bring in. As you look at the title, it doesn't talk about all entities in the title, so you may want to consider a title amendment at some point in time. Thank you.
Thank you, Mr. Dietrich. Further proponent testimony in the room? I don't see anybody moving forward. We have a Ryan Wordman who is online. Are you prepared to testify at this time?
I am, Mr. Chair. Thank you.
Any relation to Rob?
Perhaps. Do I want to claim Rob? Sorry. No, yes, he is my brother, so thank you. I'm just here as a multiple business owner from Springfield, South Dakota. I currently file 8 annual reports on my own. And I believe there's 5 different months of those 8. Some of those anniversaries fall in the same month. I just think this is a great bill to help streamline some of the operations, not only for business owners, but also different trust departments and things like that as well. But giving the option to some of those that may be overwhelmed by a single date, I do think it was a good amendment to give the option for that as well. I think this creates good efficiency opportunity for the businesses, and I ask for your support. Thank you for your time.
Thank you, Mr. Wordman. Any further proponent testimony on 1102? Seeing none here or online, we will close proponent testimony and move to opponent testimony on House Bill 1102. Seeing none in the room and none online, we'll waive rebuttal and go to committee questions. Are there any questions for the proponents? Seeing none, we'll end questions and go to committee discussion and or action.
Mr. Chairman.
Senator Dibert.
I would move to pass.
Second.
We have a do pass motion from Senator Dybert, second Senator Pischke. Any discussion on your motions?
Very little, Mr. Chairman. So, obviously, this has been a long journey, and they've worked very hard to get to this point, and everybody's in agreement, and it's an efficiency that we should do. So I ask for your support.
Further discussion? Seeing none, it's a do pass motion by Dybert, second by Pischke. Secretary, please call the roll.
Senator Dybert.
Aye.
Jensen.
Aye.
Carr.
Aye.
Colbeck.
Aye.
Larson. Excused. Pischke.
Aye.
Voigt.
Aye.
Perry.
Aye.
Melhoff.
Aye.
Mr. Chairman, we have 8 ayes, 1 excused.
House Bill 1102, having received a unanimous vote, is hereby passed. We'll go to the floor with a do pass motion, and it does certify for consent. And if there is no objection, that's where it will go. So certified for consent. That concludes our agenda for today.
Chair?
Looking for a motion to adjourn by
No,
Senator
I would
Pischke.
actually like to have a personal privilege, if I may.
Okay.
On behalf of Commissioner Greenfield here in the room, I'd like to announce that the senior government class from Clark High School is just got to witness how the sausage is made. Most of the discussions that on how bills are passed are actually happen in committee rooms just like this, and you just saw a bill get passed from Senate committee, and that will be debated on the Senate floor tomorrow, or, well, be on the consent calendar tomorrow. But this is how it all works, ladies and gentlemen. So thank you for being here, and thank you for being part of the process. And thank you for your latitude, Mr. Chair.
You bet. Before we adjourn, we have a page that never got the opportunity to introduce themselves to the committee in the room, so.
There we go, got that too.
Welcome. Please tell us your name and where you're from and what your plans are.
Hi, my name is Olivia Moffett. I am from Hot Springs, and my future plans are to go to business school, and I'm going through Southern New Hampshire University, and then I plan on going to law school in Florida.
Excellent. That's an ambitious agenda that you have. So for those in the room, the pages come and work for 2 weeks here. If any of you would ever like to do it, give it some thought. So at this time, I'll take a motion to adjourn.
So moved.
Second.
Motion by Pischke, second by Perry to adjourn. All in favor say aye. Aye. Opposed, same.
As South Dakota's public media network, SDPB serves everyone with transparency, integrity, and commitment to open access. Good, useful, and full of wonder. SDPB.